Good afternoon and welcome to the July 28th meeting of the San Francisco Ethics Commission. I'll take attendance. Chairperson Mr. Herr has been excused for personal reasons, and call the other commissioner. Ms. Han? Here. Commissioner Andrews? Here. Commissioner Keene? Here. Before taking public comment on the item number 2, I just want to call everybody's attention to the fact that the regular meeting for August has been canceled, and there will be a special meeting on August 18th at 10 a.m. in room 416 to consider the report of the civil grand jury and the commission's response thereto. At this time, I will take public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Members of the Ethics Commission, Ray Hartz, Director San Francisco Open Government. In 1964, here in San Francisco, Senator Barry Goldwater accepted the Republican nomination for president, and his very brief and concise acceptance speech included some items that were boiled down to the following. I would remind you that extremism in the defense of liberty is no vice. And let me remind you also that moderation in the pursuit of justice is no virtue. And I want to make it very clear that any citizen, including myself, has the right to come here and tell you stuff you don't want to hear and talk about your performance as members of this commission and this commission as a whole. And yet, the pattern here seems to be that you joke about it and you act like when members of the public come here to talk to you that they're being specious or anarchistic or whatever. And the perfect case was that when we were talking not too long ago, and you were joking about it, well, you think we're trying to hide stuff. I don't think you're trying to hide stuff. You hide stuff all the time. That's what you're here for. You are here not only to hide stuff that you do, you are here to hide stuff that other city agencies do. This Ethics Commission is a waste of the resources used for its operation. It is nothing the citizens of San Francisco could have imagined when they voted for its establishment to ensure open government. Anyone who wishes to put even a minimal effort can examine the record and see that this body has done absolutely nothing over the course of its existence to open government and has done everything possible to hide its secrets, including illegal actions, from the public. 3 commissioners, Commissioner Herr, Commissioner Rennie, and Commissioner Hayon, are political flacks answerable only to those who appoint them. That is not a personal attack. It is my personal opinion, and I base it on years of watching you. You do nothing but protect the people, and in my case that was heard without my presence, Commissioner Hayon participated, defended the person that was on the opposite side of the case, talked all about all the reasons why they were right and I was wrong, and then at the end recused herself to avoid the appearance of a conflict when she had actively been in a conflict during the entire proceeding. I had sincere hopes for the new commissioners, but although they talk a good game, there is nothing that I have seen from them that indicates they will not just follow the lead of the other members. I have challenged you before. Come here before the public and give us examples of how you have improved city government. You never do, for the simple reason you can't. You don't do a damn thing to make government in this city better. Nothing. In fact, you are the antithesis of what the citizens of this city intended when they passed this law.
Good afternoon, Commissioners. I'm going to hand the Deputy City Attorney a document that I want distributed to each of the 5 Commissioners and my written testimony, which I've already submitted to Mr. St. Croix and Mr. Chatfield. I'm Patrick Minetshaw. I'm here on my own time, as usual, as a private citizen. I am distributing to Ethics Commissioners a new complaint documenting that Sunshine Ordinance Task Force member David Pilpel has failed for over 130 days to file the required annual Form 700 Statement of Economic Interest, SEI, by the required April 1, 2014 due date. On June 23rd, I provided you commissioners copies of a different complaint regarding Mr. Pilpel's probable violation of the Statement of Incompatible Activities, SIA, that is applicable to task force members. During the Ethics Commission meeting on November 25th, Commissioner Keene thankfully raised a question regarding having a discussion about the Ethics Commission's executive director's power to dismiss complaints unless a commissioner pulls it off of the consent calendar. For both the SIA and SEI complaints against Mr. Pilpel, I strongly urge this commission to require that a public hearing be held on each complaint, and that both complaints be addressed by the full Ethics Commission as expeditiously as possible. State and local law, of which Pilpel must be surely aware, provide that filers who are more than 30 days late filing their Form 700s are subject to a fine of up to $5,000 per violation. And willful failure may be a misdemeanor offense. There is no exemption in state law to let Mr. Pilpel off the hook. At a minimum, he should be fined at least $800 at $10 per day for the 80 working days past April 1. Or if the fines are based on calendar days, he should be fined at least $1,170 for the 117 calendar days that have passed since April 1. However, given the severity of his flagrant violation of the public trust, he should be fined the $5,000 per violation penalty. Given the egregious nature of his conduct, I respectfully request that the Ethics Commission find and determine that Pilpel's discipline should include a recommendation to his appointing authority that he be removed from the Sunshine Task Force. And given the egregious nature of having failed to file a Form 700, it is only appropriate that a remedy include a recommendation to his appointing authority that you recommend he be removed from the SOTF at once.
Any other public comment? Turning to agenda item 3, discussion and possible action on a matter submitted under Chapter 3 of the Ethics Commission Regulations for violation of the Sunshine Ordinance, attachments, memorandum to commission, hearing notices, report and recommendation, and appendices A to C. Ethics complaint number 02140228, hearing regarding alleged willful violation of the Sunshine Ordinance by a department head referred from the Sunshine Ordinance Task Force on February 28, 2014. Task Force complaint number 13024, complainant Micah Ringel, respondent John Ram, Director, Planning Department. I call for any public comment.
Not yet.
Pardon me?
Not yet.
Not now?
Not yet.
Okay.
First, Catherine.
Do you have there was a report, I think, of the staff and a recommendation? Have you heard that?
Yeah, so that, is Mr. Rengel here? Is there someone from planning here? Okay.
All right. Want to be heard?
Catherine, how long does he have? 5. Okay, he's got five, you have 5 minutes, please. Huh? 10?
10 minutes, yes.
Sorry.
There was no communication from Mr. Rengel as to his appearance?
My understanding was that he was going to be here.
He was going to be here. Go ahead.
Commissioners, Jonas Ionen with the Planning Department. I'm the Director of Commission Affairs, and as part of those duties, I'm the custodian of record for the Planning Department. I'm here on behalf of Planning Director John Ram. I won't need hardly the 10 minutes afforded, but I'm just really here to respond to any questions that you may have. We concur with the staff's recommendation and respectfully request that you find that John Ram did not willfully or non-willfully violate the ordinance. Thank you.
Are you Mr. Regal? All right. You want to, your case, the matter has been called, and but you want to be heard on it?
May I ask questions of
Well, I thought maybe we would, because the order we would have gone was to let the complainant make his statement and then take it, but I agree with you. Okay?
Members of the Ethics Commission, hello. I apologize for being a little bit late. So I first began interest in this case because the Planning Department was approving a project across the street from my house. And so I was told by a land use attorney to specifically request the entire case file, not just the documents that were made available in the public case file. And she specifically said to ask for all communications. She said it's very important, including emails. And so made a request, not knowing what the Sunshine Ordinance was, for all documentation that they had for the project, including correspondence. Don Lewis, formerly employed by the Planning Department, because both planners have been let go, he promptly replied, and I went in the next day to go see his case file. It contained minimal correspondence, and I was surprised to find that correspondence from my own family was missing from the case file. And so...
What did the case file contain?
It contained...
Can you give me the approximation of what the volume of paper was?
Sure. It contained maps, plans, architectural plans, technical reports like shadow studies. It contained geotechnical reports. It contained of the like. And so then I waited 10 days and I hadn't heard back from the other planner, Ben Fu. And I emailed him again saying, second request to see your case file. And Ben Fu's response was, if you're making a request under the Sunshine Ordinance, you need to do so with Lulu Huang. If you'd like to see my case file, it will be at the front desk for you tomorrow. So I went in the next day to go view Ben Fu's case file, thinking maybe the emails that I had sent were in his case file. I didn't realize that the Planning Department segregates their files as a rule. Like, that's just how they do it. There's the E case file, the X case file. They all stand for different parts of the environmental review or project review process. And so my emails weren't there either. And what was even stranger was that his graphics folder was empty. His correspondence folder was empty. And I took a picture of these because I thought it was really, interesting. And so, not knowing what else to do, I had to research what the Sunshine Ordinance was. And so I made a request with Lulu Huang, who is the department staff in charge of the Sunshine requests, or formerly in charge of Sunshine requests. And so what then began in this ongoing series of emails, different than how it's stated in the report to you, it states that I was eventually given these documents, although timely, but there are dozens upon dozens of letters and emails that were excluded from your report, although I gave them to Ms. Adjournment. with the planning department saying, I need these files, we're coming to hearing. And so I was given minimal amounts of correspondence. Mostly the correspondence I had sent them was given right back to me. Meanwhile, I'm waiting for the planning commission hearing. Because the Sunshine Ordinance Task Force had a delay in hearing cases because there was a backlog because they didn't have enough members to make a quorum, when my case finally came to be heard, the planning department had already pushed forward the project to the planning commission, and the planning commission at the first hearing wouldn't approve this project. Immediately prior to that, I had gone to the planning commission and during public comment requested their help to help me get these case files, because since then I had learned that there's an exclamation point file and a K case file. And the K case file is really important because that's the shadow study case file. Because I had been repeatedly told that I had been given all information related to the 480 Potrero Avenue project, and that was completely not true several times. I was given access to the K case file on June 6th, immediately before a hearing was scheduled on June 20th. That later had to be postponed for other reasons because the developer didn't give proper notice. But when I was given access to that K case file, which was sequestered on the 5th floor of the department, I opened it up, and there is a failed shadow study performed by the planning department for this file, and they had sent a letter to the developer stating, we cannot approve this project because it will cast shadows on Franklin Square Park. Now, mind you, this building is going to be, well, it will be, the second tallest building on Potrero Avenue next to the new wing of SF General Hospital. So we're talking about a pretty sizable building as it is. But the fact that the planning department has issued a negative declaration for compliance with the California Environmental Quality Act, only referencing this favorable shadow study, the one that was in the case file that I was given access to. So then an order of determination is issued, and at a vote of majority of the Sunshine Ordinance that was there at the first hearing, just immediately prior to them issuing an order of determination, that the planning department was to comply. Excuse me, just let me catch my breath for a second. Thank you. The project had already been approved by the second, I was like a week away from the second planning commission hearing where they actually approved the project. And so there was still time had they given me the information that I needed at that point. But by the time the order of determination was issued, it had already gone through the administrative process to the Planning Commission. So that left me and my neighborhood group, the Mariposa Utah Neighborhood Association, no other choice but to appeal to the Board of Supervisors the determination of the Planning Commission and to the Board of Appeals, which we did unsuccessfully. What in between that was the second Sunshine Ordinance Task Force hearing on the matter, which was with the Amendments and Compliance Committee. At that hearing, they were told to, Don Lewis was there for that hearing. He said he was told by a city attorney he did not need to comply with the Sunshine Ordinance requests for any materials before I had requested, only post. So that's why he was only supplying me with emails that were basically of my own that were coming in. Because what I was interested in was the information up to 2011, 2012, when this file first started opening. And so I can kind of cut my story short, is I was given several CDs. Each CD had different information on it. And the planning department never performed the searches as requested the right way with the Department of Technology. The closest they got was the CD that I was given 10 days after the Board of Appeals hearing, which was the last possibility for administrative review without seeking judicial review, because that's how it is with the California Environmental Quality Act. After the Board of Appeals makes their determination, you have 10 days to file a rehearing request. The planning department complied substantially with the request 12 days after, meaning they pushed the project forward while holding back the information that I needed, because the information on that CD that I was given at that time, and it was one of the members of the Sunshine Ordinance Task Force was like, we have a computer right here. Why not stick it in and let's see what's on there? And right there in the middle of the hearing, I am seeing these emails that have to do with the failed shadow study. And so everything I had been saying to the Board of Supervisors, to the Board of Appeals, the planning department was rooting for the project, pushing it forward while saying we didn't have any, so they were pushing the project forward while holding back the information. As far as why is Mr. John Rahim here on charges from the Sunshine Ordinance, I could sum that up with he's in charge of the planning department. He knew about this. In fact, I have since been given another CD as part of discovery, if you will. SEEK was reviewed by the administrative record from a deputy city attorney who's in charge of that case. And I have emails here that I've never seen before. I brought copies for you. I don't know if you're interested in them. Like, I didn't know the SFMTA actually reviewed this project. That's never shown up in anything from the planning department, although I've been told I've been given everything that there was. There is all these things from the shadow study where, long story short, the planning department never complied with the request. And when they were supposed to, the very last time, right before the referral to you, the Ethics Commission, the search terms I had given to Jonas Ionin, who was representing, he was John Rahim's agent at that hearing. In lieu of John Rahim was Jonas. I only found out from this Ethics Commission report what happened with that last search, because there's like minimal CDs on there. It should have had minimal files on there, emails. It should have had everything. What happened was Jonas, for the fourth time to the Department of Technology, this time he decided to ask for the right search terms, but only for the deleted emails. So not everything that wasn't deleted that I had asked for, just the deleted ones. And so I found that out only from the report to you. The planning department has minimally complied with these requests repeatedly, and every time they kept saying, you have everything that there is. And I'm still getting information.
What's the volume of documents that you received from them all told?
The volume of documents?
What are we talking about?
Well, they were all CDs. For instance, the CD that I received this last time, the last file was cut off, so I never got anything there. It was there's only so much room on a CD-ROM, but it'll let you burn like the last little bit of it, but if not the complete file, you can't open up the file. So for instance, Bill Wykos, whose last name is a W, I never got that information. And if I did, it only would have been anything he deleted related to the project. But how many were we talking about? We're talking about 100, 200 emails maybe for the core planners. The rest of them, they somehow had a part of the project. I'm just now getting Diego Sanchez's, the shadow consultant who works for the planning department, his emails, and out of a bunch of stuff that wasn't related but showed up for the search terms that I got from the city attorney, there's 6 of them that clearly say, I need to talk to you about this project. And then there's an email here saying, just lower the height of the building. We're going to ask for lower plans. I already put the negative declaration on my supervisor's desk, and she's out for the week. I mean, this is like the information that we were exactly needing to appeal these projects. And so
I think you exceeded your time.
Yes.
I don't know if any of the commissioners want to ask any questions at this point.
I'd like to. No, I don't have any questions, but I will want to hear the response from the planning representative.
Thank you. I'll separate them while he's speaking. Thank you.
You want to, planning department want to come forward and give any response to the sequence of events that he described?
Well, again, Jonas Ionin for the planning department. Our responses are really contained in the report. We concur with the chronology and the events as the investigator laid them out before you. What I can say is that over the course of several years now, we've tried to comply with every request that Mr. Ringel has made. As a result of attending the Sunshine Ordinance Task Force, we actually went to DT, which is not our common practice, to request deleted emails that were no longer within our possession. We did that twice. The first time was not satisfactory to Mr. Ringel or the Sunshine Ordinance Task Force. We did that a second time with specific terms and planners that work with the planning department to search their deleted files, and provided him with that information, basically transferred a CD provided to us from DT. Again, I'm just really here for any questions.
Mr. King?
Just a question on the deleted files. How often do you delete files, or how quickly do you delete files, since it seems to me there are quite a few deleted files that you've both referred to?
The planning department's practice is basically to retain substantive correspondence. So if the email is determined by the planner to be non-substantive, then they're deleted and not retained in the official record.
They're immediately deleted?
Well, I mean,
shortly after they've been...
Shortly after or whenever the planner
received.
Gets around to it. Everybody has their own system.
Okay. So there is no standard system throughout the planning department as to when any files or emails are deleted. It's up to the discretion of the individual planner. Is that what you're saying?
It is, but the direction is that only non-substantive matters or emails and correspondences get deleted.
Okay, thank you.
I'm sorry, I didn't get your name, sir.
Jonas Ionin.
Jonas Ionin. And what is your position with the planning department?
I'm the Director of Commission Affairs, so primarily I'm the Commission Secretary to the Planning Commission and the Historic Preservation Commission. As a part of that, my responsibility as of November 1st of 2013 has been the custodian of records.
Did you have any kind of supervisory duty over the people who were talked about in the report, whom the gentleman has said that he dealt with and had problems getting the various documents that he was asked for, and they sort of dribbled out documents to him over various periods of time? Are you the supervisor of those people?
Not at the time that he made the official request. That responsibility was transferred to me from Tom DeSanto.
From whom?
Tom DeSanto.
Okay. And in regard to Tom DeSanto, he was a supervisor.
He was the custodian of record at the time.
And who did he report to?
He reported directly to Director Ram.
Okay. So he was, right above him was Director Ram, John Ram.
That's
Is that
correct.
And so I would take it then that in regard to any sort of things that were done that were in violation of any kind of rules or regulation by these individuals who were named in the report, that at some point Mr. Ram would have been informed of that if the supervisor knew of it, and that he would have then taken some disciplinary steps?
Well, he would have been informed if the department felt that they were not in compliance of some sort, or if they felt that the planners involved were not responding in a timely fashion. And to the best of my knowledge, there was no such understanding by the supervisors at that time. In other words, we felt that the planners were responding in a timely fashion, and were supplying Mr. Ringel with all of the emails that were in the possession of the planning department.
Well, you've indicated that you agree with the report as it's set out, the report of our staff in relation to the chronology and the way this all happened. Is that correct?
That's correct.
Okay. And in the report itself, it does mention a number of times that the gentleman asked for various records that he was entitled to under the Sunshine Ordinance Act and under the Open Records Act, and was not given them, and then was given them later than the period that he had asked for them. You're aware of that?
Yes.
Okay. So what you're saying is, when you agree with the report, then you are agreeing that in regard to your department did then violate the particular rules relating to the obligation to turn over these materials at the time they should have been turned over.
Yes, we will contend that those were non-willfully done in that manner.
But they were violations, and you accept the fact that your department violated those regulations, whether willful or non-willful. The materials that are referenced in the report that should have been turned over, they weren't turned over at a timely fashion. They may have been turned over later, but they weren't turned over at the time that they were supposed to be.
That's correct.
And you're aware that that's a violation of the Sunshine Ordinance and also the Public Records Ordinance in regard to a city department having an obligation to turn those matters over timely. Is that correct?
We are, in fact.
So just to sum up then, you are stating to us that the planning department did violate those particular sections which are referenced in the report of our staff.
We did not provide some of those materials in a timely fashion, yes.
Which was a violation of the rules as reflected in the materials that are put forth in the report of our staff. You've already said that you agree with it.
That's correct.
Okay. I don't have anything further.
Mr. Iona, thank you for your recounting. And Commissioner Keene, that helped me. I was going to come at it a little differently and want to find out, would you treat this same request the same way? How would you treat the request that came from Mr. Rangel? How would the department treat that request today? The exact same way?
It's treated similarly, but since I've been appointed custodian of records, we've made some procedural changes. In fact, we've added staff to my small office within the department to specifically target these types of public record, well, all record requests, really. And so we have a better procedure in place to identify those planners who are involved with processing materials. So, in fact, for example, Ben Fu and Don Lewis were not the only two planners who were working on this case, but they were the primary respondents to Mr. Ringel's record request. And so as part of that, some of those records were not provided to him because they were not in their possession, but in the possession of other planners.
So you may still be developing these internal protocols, but it sounds to me that there are changes that you're making within the department.
There are fairly drastic changes that we are making. I'm currently in the process of revising our record retention policy, the matrix associated with that. It'll be brought to the Planning Commission for their approval and then forwarded to you for yours.
Question?
If I could follow up, when you say that Mr. Lewis and Mr. Fu were the principal planners, but there were others involved, when they got the document request, was it your department's policy that they only produce what they have and nothing else?
No.
What is the policy?
Every public officer within the city and county of San Francisco is actually a custodian of records. So when a request is made to any individual, that individual should be pursuing that to make sure that the request is satisfied.
And you say in this case you conceded that to the extent that it was produced, much of it was not timely.
I wouldn't say much of it. Some of it was not timely.
And you understood the request was in connection with a challenge that some residents was making to the project, right?
Yes.
And did you do anything to slow down the approval of the project until you had complied with the request?
Myself, no.
Well, does the department have any policy about when a citizen makes a request for documents which would support, or at least they believe would support their challenge to the process, that until it's been fully complied with, no decision should be made?
Our policy is to respond to record requests in a timely fashion, and at that time, the people who were responsible for the record request felt that they had responded to Mr. Ringel's request.
Now, is it unusual that there would be nothing in the correspondence file?
Not necessarily. It depends on when the file is being provided to the person. Clearly, at the beginning of a case, there probably will be nothing or minimal number of correspondences in a particular file, and it depends upon the complexity of the case, whether or not anything is in the correspondence at the end of the, when it's closer to the hearing.
But what kind of materials should be placed in the correspondence file?
Any hard copy correspondence and emails as well.
So correspondence from the developer or correspondence from any consultant?
Any substantive correspondence.
But it didn't surprise you to learn that, I think it was Mr. Fu said he had nothing in his file?
I don't believe Mr. Fu said he had nothing in the file. When I spoke to Mr. Fu prior to his departure, and just for clarity's sake, neither of those two planners were let go by the planning department. They left on their own accord. He explained to me that he did print out emails and then put them in his correspondence folder. So it's a surprise to me that Mr. Ringgold didn't find anything in the correspondence folder.
Anybody have any further questions?
So I just wanted to be clear. So, and I don't want to put words in your mouth. So are you saying there very well could have been correspondence in the file, and Mr. Rangel missed them? You said you were surprised to find out.
I was surprised to find out that Mr. Ringel found an
why.
empty correspondence file. I can't speak to why that is. All I know is what I was told by the planner himself is that when he receives a record request, that he prints out the emails the substantive emails associated with that case, that he actually files electronically in his inbox. So he creates a folder for each of his projects, and then he prints out those files and puts them in the correspondence file.
So I just want to go back to then the definition of what is substantive, and if that is a definition that has been generally shared with your planners and other personnel at the planning department, because it seems to me that if that is subject to each individual planner's perspective, then you may find a wide array of what people consider or don't consider substantive. So some standardization of that throughout the department certainly sounds as if it would be important. Are you doing anything about that definition at this time? You said you were undergoing some big changes.
Thank you for that. And as a part of our revision and updating of our record retention policy, we are trying to provide clearer definitions to what we consider substantive. But it has been conveyed to staff, and non-substantive emails are really things that don't pertain to the project itself. Right? If someone's asking to see a docket, we're not going to retain that request, right? If someone's asking what time the hearing starts, we're not going to retain that email, right? But if they're commenting on the project with substantive comments, then that email does get retained.
I know that we offer online training in terms of the Sunshine Ordinance Task Force, and I assume that all of your folks at the Planning Department have taken that training. I don't know if you have checked that or not, but I guess my question beyond that would be addressed to the Sunshine Ordinance Task Force as to whether or not the task force ever does in-person training or meetings with different departments. I mean, some departments in a way are more important than others. The planning department clearly is a very important planning department in the city, gets a lot of attention, a lot of scrutiny. So it might behoove, either the Sunshine Ordinance Task Force perhaps to really sit down with you and some members of your staff to discuss what is, some of these issues that you're faced with. particularly when you have requests for information and for documents. So I don't know if that's something that you would want to approach the Sunshine Ordinance Task Force, or perhaps during public comment if there's someone here from the task force that would like to comment on that. But I think that these things can get a little murky depending on definitions or how the rules are interpreted by employees of a particular department.
Currently, we're consulting with our staff at the city, within the city attorney's office.
Yes. Have you talked with Director Ram about this matter before your appearance with us tonight?
Yes, he's very well aware.
He is aware of it.
Yes.
And he's aware of the fact that the Sunshine Ordinance Task Force has at this point made a finding against him that he violated these various ordinances?
Yes, he's aware.
He was aware of that. And is there any reason, did he tell you any reason as to why he would not come before us and give us his view of why we should not uphold the Sunshine Ordinance's finding of him having violated an ordinance? Was he busy tonight, or was this too insignificant for him to speak to?
No, this is not too insignificant. It was my responsibility to come and represent the planning department. I would come and represent any other staff person. But quite honestly, Director Ram had so very little to do with the Sunshine requests of Mr. Ringel that the finding of your investigation that he willfully or not willfully didn't violate the ordinance is just that. I mean, he doesn't directly supervise the people who are responsible for collecting the information. He didn't respond to Micah Ringel personally regarding the matter. So the way I see it, there's no violation against Director Ram, with the exception that he oversees a very large department with a lot of responsibilities.
Well, but the record as it stands before us right now, as you're well aware, as it comes to us from the Sunshine Ordinance, is that Mr. Ram did violate the ordinance. And the question is, are we going to sustain that, or are we going to do something else? So given the fact that there has been a finding that the Director of Planning of the City and County of San Francisco violated ordinances relating to open government and providing of materials under the Sunshine Ordinance, do you think it might have been not have been appropriate for him to have come before us and told us why he thought we should not sustain this?
Well, again, I'm here on his behalf.
I understand that. I'm asking.
We respectfully disagree with that finding, and we agree with the recommendation provided to you by your staff. And so,
is he busy tonight?
I don't have his calendar, sir.
Commissioner Andrews?
2 points, and I may need the Deputy City Attorney to chime in on this. So was Mr. Ram's name added by the Sunshine Ordinance Task Force as the respondent after it? I see it's listed in the complaint after, and is that appropriate? Do we need to have a discussion about that? It sounds that you have to have a name to it. You have to put a respondent's name. It was an after-the-fact name that was the department head because he's responsible. I believe these other folks are listed in there. So there's that piece, and then I have one more thing that I want to get to, but I think we should take this one first.
I mean, the referral from the task force is exclusively on the question of whether Director Ram willfully or non-willfully violated the Sunshine Ordinance. The proceedings before the Sunshine Ordinance Task Force focused on the question of whether the other employees of the planning department violated the task force. I don't think that there was an adjudication of the question of whether Director Ram had willfully or not willfully violated the ordinance. I don't know why the task force, adjudicated the question of whether other employees had violated the task force, but then the referral was exclusively on this other question. Nonetheless, the one and only question before you is whether Director Ram either willfully or not willfully violated the ordinance. So it requires, either personal involvement or if there's circumstantial evidence from which you could deduce that he was involved or not involved, that's what you would have to consider. But just the question of whether his employees violated the ordinance, that's not what's before you. That's relevant only insofar as it relates to whether Director Ram willfully or non-willfully violated the ordinance.
And I just want to say, we've been here before, and this is the challenge of what we called an appropriate referral that I'm seeing one audience member who had referenced it a couple times, an appropriate, accurate referral that has us now having this conversation, and arguably, while interesting and has bearing, I'm not sure that we're actually getting to the overall cause, which is of this whole situation, which I want to get to after we talk through this.
Right. I can only tell you that I don't know why it was that the task force didn't either adjudicate the question of whether Director Ram had violated the ordinance or refer to you the names of the people that it had actually found violated the ordinance. I don't know the answer to those questions. I can tell you that what the commission is sort of confined to tonight is just the question of whether Director Ram either willfully or not willfully violated the ordinance, and the question of appropriate or inappropriate referrals is in some ways sort of a broader discussion.
Yeah.
Well, Commissioner, let me say this is the second time that this has come up. Now, the city attorney, as I understand it, advises the Sunshine Task Force. Is that true?
There is a deputy city attorney who
Right.
does. I don't know what advice was given on this subject.
The Sunshine Task Force dutifully went to identify the 3 individuals who were involved and conducted their investigation and had those 3 individuals come before them. Mm-hmm. They made a finding, and it seems to me that it should have been incumbent on the city attorney to tell them, look, the issue you had before you was not directly to the department head, Mr. Ram, and if you want to send a charge to the Ethics Commission, not only on these individuals who were involved, who violated, but you should give Mr. Ram an opportunity to appear before you and testify as to why he shouldn't be responsible and charged to the Ethics Commission. And then we could deal with it.
Sure.
Now this is the second time where we've been told, well, because the referral wasn't by the right party, and Mr. Ream hasn't had his due process, which I agree with in a sense, but it's just frustrating as to the Sunshine Task Force was doing its job, and then somehow or other, the referral comes up this form.
And I hear you. I can't speak to the question of because I don't know whether the advice was provided to the Sunshine Ordinance Task Force with respect to the referral, and whether maybe it was provided and the advice wasn't followed, or maybe the advice wasn't provided. I don't know. It sounds like Mr. Minardi has some follow-up.
Jesse Minardi, Deputy Executive Director. Sympathize with what you're saying, and we were in the same boat. We get the referral, and it's somebody different than the underlying hearing. What we tried to do in this instance is give effect to the, it seems like, apparent intent of the Sunshine Ordinance Task Force to have this be a hearing with respect to John Ram. I would note, and the investigator is, Catherine, is more familiar with the underlying facts than I am, but it does indicate that the deputy city attorney there at the task force did sort of advise them that, in fact, they shouldn't be naming Director Ram as the respondent because that wasn't the person that was subject to the underlying hearing at the time. So, faced with this situation, and we share your frustration, we thought the best thing to do was to take it as it was provided to us, particularly given the last case that we had here and what we thought was sort of the intention of the commission. And so we had Mr. Ram named as the respondent per the request of the task force.
Commissioner Keene?
Mr. Chair, as is reflected by my colleagues' comments, this is very disturbing now. We've now had this twice. It's almost like a game that comes to us in terms of someone has violated a particular ordinance, some very important ordinances, a few months ago in regard to the Park and Rec with Mr. Ginsburg and some others. We were told we could not have any kind of finding against the head of Department of Rec because it was these underlings who had actually done the grunt work in whatever the violation was. And now we're told by Mr. Minardi that in regard to the planning department, or excuse me, the Sunshine Ordinance Task Force, they were advised by the deputy city attorney at the time that they should pursue this with the underlings rather than Mr. Ram. And now we're told, well, no, you should have done it with Mr. Ram. This is sort of like Lucy and the football.
Hearsay.
Let me finish. But I want to pursue something further, and that is I think we have enough evidence here, and we should make a finding that Mr. Ram violated this ordinance. And the finding can be based upon the fact that it can be either a willful or a non-willful violation. There's certainly enough evidence before us that it's to sustain a non-willful violation, given the fact that we have in the record tonight that Mr. Ram is the head of this organization. He has one mid-level supervisor between him and these underlings who do these tasks. They report to that one mid-level person. We've been told that Mr. Ram will discipline them if they do things that are in violation of any kind of ordinance. Therefore, implicitly, I think we can make a finding that in regard to this whole chain of activity, that Mr. Ram was indeed involved. He was the one in charge. He was the one giving the orders. He's the one ultimately responsible. It's his department. We see that an ordinance has been violated. So rather than just sort of slink away like we did a couple of months ago and say, well, we got the wrong guy here, I don't think we can accept that. I think we have to make a finding that someone is responsible, and the responsible person is the head of the organization, and that's Mr. Ram. Since we have an admission that the ordinance was indeed violated by his representative, that admission comes from his representative here tonight. And I just don't think we should drop this. We wouldn't be doing our duty to the citizens of San Francisco in terms of telling them that we take seriously the fact that a particular department, when it's told to turn over materials that the Sunshine Ordinance and the Open Government Act require them to turn over, that they just blow it off, as was done here in a number of situations. And if they blow it off, well, there'll be a bunch of hearings that will occur by a couple of different departments, by the Sunshine Ordinance Task Force, by the Ethics Commission. There'll be lots of words expended, but nothing will happen. There won't be any consequence. So I think when we finish up with this discussion tonight, we should have a finding that Mr. Ram violated this ordinance.
Chairman, I just wanted to build on Commissioner Keene's point, which is simply this, and I agree. I think this was a clumsy and inelegant referral that has us talking about not the substantive component of it, but if and as I heard it recounted within the department, there were some untimely responses to the submission for the request for documents. You have to have a culture of accountability, and in Mr. Is it Iona? Iona, in your recounting of it, you said everybody felt like they were doing the right thing, so there was no reason for Mr. Rand to be involved. And in fact, if there was an agreed assumption that we're all doing it right, at some point the accountability works its way up to the top. So whether the referral was made properly or improperly, if you're going to change the culture of an organization, it usually has to start at the top. So that would be my argument for why we would move forward, and I would support Commissioner Keene's recommendation. But for me, the more substantive piece is, and I don't know that there needs to be this, a question beforehand was asked, if there is a record request or a similar request put forward from this point on, is there a trigger mechanism that would slow down the administrative process so that the person requesting records, clearly needing these records and documents for their particular interest in the project, is there any mechanism in any way? Has it ever happened? Is precedent ever been set where a project has been slowed down because you haven't fully given information over to what would either be just a person requesting information or possibly someone who was an opponent of the particular project in a department? Have you ever heard that? Yeah.
Actually, not that I'm aware of. It's an interesting point you make. I'm not aware of any process being halted because the Sunshine request hasn't quite yet been fulfilled. Having said that, there is an appeal process tagged on to any kind of a decision made by most commissions, or even administratively for that matter, to afford anybody their due process. If something
so that in Mr. Ringles, when he recounted when he got his documents, which in some case, a couple cases, and at least how he recounts it, were past the time, stalled, delayed, if not actually past some due dates where he could have submitted. Do you know that to be the case? Do you know when some of those CDs were released to his possession?
Well, certainly some of the last ones, but those again were deleted emails that, in our opinion, were non-substantive to the matter. I mean, my understanding, since I've sort of adopted this matter, is Mr. Ringles' requests were specific to correspondence and emails. And so when it went to the Sunshine Ordinance Task Force, it was referred to them because one of his family members' emails was not included in the correspondence that was provided to him in response to the record request. We would contend that it's just a non-substantive email. In fact, I still haven't even seen it, so I mean, I can't really speak to it. But that was the crux of why it got to the Sunshine Ordinance Task Force.
Thank you.
Can I ask Mr. Rengel a question? As you stand here today, are there still documents that you believe that the planning department has not delivered to you?
Absolutely. They've never complied with the search. The last search that Mr. Ionin, which was the fourth CD that I've been given, which was after 6 hearings, knowing that there was already this referral to the Ethics Commission, that it was pending, and they were warned that it would be that exact same search, but not for the deleted emails, for all emails. Anything held within the custody of the planning department was my request. And I understand I'm not a political person. Like, I only just registered to vote, which is weird, but I just never thought my vote mattered. So I want to preface this by, I don't understand the politics and stuff, but I do understand the Ethics Commission as far as the relationship with the Sunshine Ordinance Task Force. It seems to be strained because they didn't want to send this case here. I asked them to, so that there could be some accountability on behalf of those at the planning department, because our faith in government is that there be accountability and responsibility. And I, after going through 6 hearings with the Sunshine Ordinance, and it was quite a long process, I could tell you that Mr. Rahim was given notice. Absolutely. He sent who was ever in charge of Sunshine Ordinance complaints, Lulu Huang, prior to Mr. Ionin, to the first hearing and to the second hearing. And that was accompanied by the acting environmental review officer, Sarah B. Jones. And because I was concerned on time, because I needed these files at least for the last administrative hearing, they told Mr. Rahim or Thomas DeSanto, who he mentioned earlier, Mr. Ionin, that they were to come to the CAC, Compliance and Amendments Committee, and that everyone agreed to waive it so that it would be at the next Wednesday, the procedural notice, and that they told him. And so Mr. Ionin didn't then show up at that hearing. And then he was taking over for Lulu Huang's position. Again, he's acting as agent for Mr. John Rahim. He knew about this all along, and so the order of determination went to John Rahim. He was in receipt of it, and so he knew that this happened. So to say that he wasn't given notice or was somehow denied his ability to be heard was not the case at all. He chose to let people handle it, and those people didn't handle it at all. In fact, I have here, this is John Rahim, if you don't know. This is from the Bay Guardian in January of last year. Land use planning in San Francisco is sometimes called a blood sport. This is the blood sport. He's talking about war here. The war was to push the project forward and then to deny me.
My question to you, though, is what documents do you believe haven't been produced to you at this time?
Well, the search terms have never been completed in their entirety. The closest was the time that was the second CD that I was given, but they put the word 480 Potrero Avenue in quotes, which means it has to be that word 480 Potrero Avenue. So it only returned those responsive documents, but who spells out avenue? Like it was so minimal. And so if they returned the search terms in their entirety, then this complaint would have been settled. But now the project's approved, and I brought this up at every step of, these are all my records requests to view public files, and so it wasn't possible that I missed anything. I mean, I was there a lot at the planning department because I needed to keep track of what was there and to see what was going on. Here is a letter after the second Compliance and Amendments Committee, the Education Outreach Committee, where I made this request of the names that I needed the files for and what the search terms were and what the search period was, because they were trying to say that nothing before 2012 because the servers they changed email servers. But you migrate your old accounts, and I had proof of that from a previous search where there was the log file, and there were searches prior to 2003 in that log file. And so none of that was making sense. So they were trying to keep these specific documents. This is not like a gross negligence at the planning department. They don't know how to comply with these requests. I've talked to a lot of people who said, I always get what I want. And I'm like, well, that means there's nothing to hide with your case. This was anyways, so then this is how Mr. Ionian deals with it, because I was informed that anything post when I made my Sunshine Ordinance complaint, I would have had to have made a new complaint for that, the last couple months prior. So to Mr. Ionian in this letter, this is a request for immediate disclosure. In responding to this request, please bear in mind, and I'm laying out the California Public Records Act to Mr. Ionian for that subsequent search for an urgent reply. Nothing. I don't hear from Mr. Ionian at all. Mr. Ionian was very adamant to the Sunshine Ordinance Task Force, and he had missed the first couple hearings, that we've given him everything. There's nothing else here. Anything's non-substantive, as he's saying. Here's an example of the non-substantive email, and it's in your packet under exhibits or addendum C. My first email saying, you have the district supervisor, wrong on the cover of the preliminary mitigated negative declaration. So that was later revised and wasn't taken care of. So there you have an in fascia on the face error of information, and they just, and they can't even produce that email, and they won't produce that email. And here's from the hearing, Supervisor Kim, just two things I'm concerned about. One, I'm concerned you don't keep with the file every piece of communication related to the subject matter. The clerk of the board here is in charge of keeping every letter of communication with the file. I know the technology exists and the planning department is capable of that. That concerns me. Here's me to Lulu Huang. Can you have an IT admin search the planning department servers for 480 Potrero, including the Exchange server? Because the planners weren't complying. And so this is how we went through 6 hearings. I emailed Mr. Ionin before I even know who Mr. Ionin was, and John Rahim got this message back in May 30th, 2013, asking for a continuance from the hearing because I couldn't get the case files I needed. And so there was plenty of notice. He had every opportunity. These are emails saying de minimis compliance after having exhausted every administrative appeal available to the Planning Commission, the Board of Supervisors, the Board of Appealables, has deprived me personally, my co-appellants, the 200-plus members of the Mariposa Utah Neighborhood Association, the public records we needed all along.
All right, I think we've heard enough from you on this question and understand your position on it.
I have a question, though.
Yeah, go ahead.
Yeah. Okay. So, understanding the timeline, what documents were you looking for, or what are you still looking for that you need?
It would help me greatly to have, by statute, I need everything that was given. And so I'm having a hard time still getting all the information. I'm still getting new information through bits of discovery with the city attorney assigned to judicial review. But I believe that there's more because he's not running that search properly either. And now I have to make a motion for log files. I mean, it's really like this game.
But, okay.
I believe that there's more.
What do you think you're going to find that is going to be beneficial to your case or your argument? Presumably, obviously, you're against this project, or you have concerns about this project. So what is it that you don't have yet that you need?
I have for you copies of some of the emails I got last week after your report says Mr. Ringel, we believe, has gotten everything. I was surprised at Ms. Argumento after, because I spent hours talking with her and sending her files and a lot of pages. Here's examples of emails I just got last week that are bait stamped from the city and county of San Francisco that the project went to the MTA. We were told that it didn't. That requests for information from reporters, like I could have contacted that reporter so that we could have, I mean, this is definitely public information.
So you're still looking for information that's in the files that can support your argument for your point of view on this project. That's all I'm trying to get at.
There is a provision in the California Environmental Quality Act Public Resources Code that says the information disclosure provisions are so central to CEQA that a violation of them is to be considered a violation of CEQA, even if a different outcome may not have occurred. So this is really important to me. I wanted to come here because I believe that you are the ones who, and they were reluctant, but 8 to 9, which is to that group, they all, over the 6 hearings, they all changed their minds the more and more that they heard and the more and more noncompliance that they saw, and it was their order of determination that was not followed. And Mr. Rahim had definite knowledge of that. And so it would help me a great deal to have something that was, they did not comply.
And where is the planning process now that this project has been approved? But I assume you could file an appeal and that, I mean, I don't know. I'm sorry?
Point of order.
You can't raise a point of order. You're not a member of the commission.
Cannot.
You can't raise a point of order.
You're asking illegal questions.
I'm asking a legal question. You're not allowed to ask him why he wants the information.
No, I don't mind answering.
The Sunshine Ordinance says you can't ask why he wants it.
I don't mind talking about it, though. I don't mind talking about it, though. Please.
Fine. I don't need to know that then.
I don't want to. No, it's.
But the project has been approved at this point.
I have exhausted every administrative possibility, and I'm here today with you. And I thank you for the continuance. Last week I hurt my foot skateboarding, and I was in the hospital, and I couldn't make it here. And so I didn't want to put it off then. If I could have, I would have been on crutches. It was pretty bad. So this is really still important to me, and I'm trying to correct something that Yeah, I shouldn't have gotten this involved in this, but the case file should have been right the first time, or the second time, or the third time. I don't know how many people get referred here after 6 hearings with the Sunshine Ordinance Task Force. They would have had a 7th if I didn't, tell them I was at the end of my rope. There's no more rope. Now I'm in court, and I'm not a lawyer. This is all I can do, and all I'm asking for is proper environmental review for my neighborhood. But when there's failed shadow studies and they're not discussed, that's an issue. It's not like this was an innocent thing. There was something they were trying to hide, and they hid it. I don't know. It's emotional to me because it's a really long road.
I think you've had more than enough
Thank you.
time. You're welcome. Any comments, any motions?
Just one last comment, and then I'll have a motion, and that is, I think people of San Francisco owe a debt to you, Mr. Ringel, because for going and pushing this rock up this mountain as you have, because I think for all of the people like yourself who get to this point, there have probably been hundreds who've given up and haven't, excuse me, have not been given the information that they're entitled to under the California Public Records Act and under the San Francisco Sunshine Act. And it seems that you're bringing this to the attention of the city as you have. You've done a service to a lot of people. I want to thank you for it.
Thank you very much. That means a lot to me, really. Thank you very much.
I have a motion. Mr. Chair, I move that we find that Director John Rahame violated the San Francisco Administrative Code Sunshine Ordinance Section 67.21A, that as custodian of the records, he did not, without unreasonable delay, permit a public record to be inspected and examined.
Is there a second?
I'm sorry. Can I just raise a point? The violation has to either be willful or not willful. So that would just be a point of clarification. Those are the options are willful, not willful, or no violation.
Then I'll say non-willful. The lower standard of proof.
And it's seconded. All right. Public comment?
I'm Patrick Minetshaw. I want to thank Commissioner Keene for taking the lead on this, but I think you're wrong. It is willful. There were more than likely 2 orders of determination. Once, when the case was heard and referred to the Compliance and Amendments Committee, and Mr. Rahim was put on notice that he had to cough up those records, that he was ordered under one order of determination to produce and then didn't, is willful, sir. There's no 2 ways around it. I need to address a couple of points of misinformation in this discussion. The Good Government Guide that Commissioner Keene has noted doesn't carry any weight of law at all. Claims the backup tapes are analogous to dumpsters. We heard that in the George Wooding case against Recon Park General Manager Phil Ginsburg. That's nonsense. There's state law that requires all records to be held for 2 years. All records does not mean that they can do at a planning department employees' whims, nor over at Park and Rec, when Park and Rec are told that when there's no more business need for a document, they can delete them. It's not true. State law requires 2-year retention. Unfortunately, Commissioner Han is proving her suburban roots again. Ms. Han, Sunshine Ordinance Task Force does not conduct training. It's very clear in Ethics Commission documents that it's the city attorney's office that conducts the training. And you're also wrong. Not all city employees take that training. Only SCI filers take that training. So if there are planning staff over there, you are absolutely incorrect that they have taken sunshine training. And I believe the Compliance and Amendment Committee is absolutely within their right to name a respondent during a Compliance and Amendments Committee meeting that may not have been on the initial complaint. But when Rahim was told on the first order of determination, produce, he should have produced. And at that point, I think the task force was fully within its rights to add Rahim as a willful violator. I think you should start out these hearings by reading the Sunshine Ordinance referral to you and note to members of the public what the case is about. Is it willful? Is it non-willful? And has it gone through CAC before it arrived here? Because those are all important factors that you should be discussing, and you discuss not one word about any of that.
Commissioners, Ray Hartz, Director, San Francisco Open Government. Thomas Aquinas teaches that willful ignorance of what one ought to know is a mortal sin. Mr. Rahim has had the department under his control for multiple years. He has taken multiple trainings in ethics and sunshine. He knows what his responsibilities are, and he knows that the buck stops at his desk. I thought maybe there was a little bit of removal, but apparently the supervisor of records reports directly to him. And I find it inconceivable that after all of these hearings that Mr. Rahim wasn't fully informed of what was going on. Now, Mr. Ionin, I think, is being disingenuous in that the reason Mr. Rahim is not here is because he doesn't want to answer the questions you asked. Because he would either have to lie to you or tell you the truth and admit his own responsibility. I served 12 years in the military. I spent 30 years in both the government and the private sector. And any person who is in charge of a department or an organization who then says, because my subordinates did it, I'm not responsible, would be fired. In the military, they would laugh him out of the hearing. He is responsible for each and every action. Now, we went through this a couple years ago, and this body took the position that if a department head or an elected official wasn't named in the complaint, that they could not take any action. However, members of the public don't know that fact. I file all my complaints, all my requests with the department head. If he or she chooses to delegate it to someone else and they screw it up, that doesn't change the fact that it's their fault. They've had a dozen years to deal with this law. They know what the requirements are, and they also know that they have an obligation as a department head, getting the salary and benefits they do, to follow the law and ensure those under their control do also. And I'm going to tell you one thing more about Mr. Ionin. 2 years ago, I attended a Sunshine Ordinance task force hearing at which Mr. Ionin claimed up and down in the hearing that he had handed over, the department had handed over everything that was available. They found him in violation because they didn't believe him, and I happened to walk out in the hall immediately after the end of the case and heard him say the following to the complainant. I know what documents you want, I know where they are, and I'm going to make sure you don't get them. He then turned around and saw me and scurried off. He's a liar. And that's one of the reasons he's in the position he's in, and that's why he's here.
I want to caution the Ethics Commission about this next speaker. He's not to hold him.
I'll have you
Out of order.
Good evening. David Pilpel speaking as an individual. I have a lot that I could say, but I'm sure that anything I say is going to be used against me. Nevertheless, I would like to proceed. Upon reviewing the staff recommendation, I'm inclined to agree that Mr. Ram did not commit a violation, willful or non-willful, of the ordinance. I generally agree that the department was delayed in their production of records. There are clearly some problems that I see with this, and you've discussed a lot of them already. The order of... I'm sorry. Can I have my opportunity to speak, please?
Every public speaker can speak, and the audience is silent. If you continue to make noise, I'll just ask you to leave.
I'll repeat that I'm speaking as an individual. I'm not representing the task force at this time. Thank you. The order of determination, which I just reviewed, found that the department had committed a violation. I'm not sure if that's the best way to proceed. I'm not sure that departments in that way violate the ordinance. I think that it's individuals who either produce records or don't. I'm not sure how we fix that or how that can be fixed at this point. This really does resemble, in my mind, the Mayanki versus Rec Park hearing that was had a few months ago. You could certainly find a violation. Maybe that sends a message, but I'm not sure if the point here is to send a message or it's to achieve compliance. And I'm not sure if, other than the person to whom a records request is directed, if someone else is held responsible for their conduct, if that actually sends the right message in terms of compliance. There really are some issues to struggle with here. I wanted to address briefly Commissioner Hand's question about training. The committee that I chair at the Task Force, Education, Outreach, and Training, has held a number of hearings about departments and their policies and procedures regarding records requests. I was intending to invite Mr. Ionin to come again to talk about the Planning Department and their policies and procedures. We generally don't do specific training, but we have here... If you have questions, I can answer on that. The one thing that I didn't see in the file was the actual referral letter from the task force. There were all kinds of other documents from the task force which were helpful in recollection, but I didn't see the actual referral letter. In summary, you could find a violation if you believe that the facts and the law support that. I think that there are still issues about who's named and whether it's the individual who receives a records request, their supervisor, or the department head, and there may be some distinctions with a small department or a medium or large department. I think it would be difficult to believe that the department head in a large or medium-sized department is involved in all records requests. If you have any questions, I can answer them otherwise. Thank you.
Any other public comments?
Can I comment again?
You've already had your opportunity to comment.
Fine, I'll just amend my complaint.
Any discussion among the... All right, there's a motion. Do you want to read the motion again? Or Commissioner Keene, do you want to state it again?
Yes. I move that we find the Director John Ram violated the San Francisco Administrative Code, Sunshine Ordinance, Section 67.21A. As custodian of the records, he did not, without unreasonable delay, permit a public record to be inspected and examined. I'm using the statutory language, Mr. Chair.
Non-willful.
And it's non-willful.
I mean, I seconded that motion, and I agree with it. I think Mr. Pilpel has raised some, very important issues about who we find responsible in these kinds of cases, as we've had discussion about this now on several occasions. But in this case, I have to say I do agree with Mr. Hartz in that in the end, we have no recourse other than to hold the director of any department ultimately responsible. I mean, I think that is true, that the buck stops there. And to try and decipher and unspool the thread of who, rejected or didn't do a timely response, I think can get a little too complicated. I think the simple thing is that an executive director of any department is responsible. End of story. Whether it's willful or non-willful is the other matter that we can certainly discuss.
The purpose of the public records statute is to get access to documents. And I guess the frustration I'm feeling is that even if we make this motion and we pass it and we send a letter to the head of the planning department, how does that get documents produced? I mean, how do we?
Can I just respond?
Yeah.
If you consult the Ethics Commission's guidelines in section 3C, it discusses the options that the Commission has in the event that it finds a violation, either willful or non-willful. I can read those to you if you like. There are three. One is that the respondent cease and desist the violation and/or produce the public records. And/or the second option, the executive director to post on the Ethics Commission's website the Commission's finding that the respondent violated the Sunshine Ordinance. And then the third option is the executive director to issue a warning letter to the respondent and inform the respondent's appointing authority or the mayor, if the respondent is an elected official, of the violation. So those are the options in the event that you find a violation, either willful or non-willful.
So if we vote in favor of Commissioner Keene's motion, then the next step is for us to make a recommendation as to which one of those options should be adopted.
Included in the motion.
Pardon me?
Included in the motion.
Well,
Mike,
that's what I'm saying. Do we include it in the motion, or do we?
Yeah, included in the motion.
All right.
And just to clarify, you could do any one of those three, or you could do all three.
Oh.
All right.
I think the way that you phrased it was you had to pick one.
So considering that, do you want to make a new motion, which I will allow the public to comment on once that motion is?
Yes, thank you, Mr. Chair. I'd like to amend the motion, and in addition to the language that is in the original motion stating the violation, I'd like to add all three of the measures that the city attorney has pointed out to us: the cease and desist measure, and I can't recall the wordings of the other two.
The posting on the website and then the warning letter. I can read. It's just I just read verbatim from the Commission's regulations.
Mr. Chair, I'd like to add all three of those to my motion.
Is that seconded again?
Yes, second.
All right, Commissioner Andrews, and I will take public comment on the amended motion.
Thank you, Chair Renee. I apologize for my behavior, but there must be some way of stopping Mr. Pilpel from speaking on behalf of the task force. He may couch it however he wants, but when he gets to the word "we" in his testimony, he's attempting to influence you as being a representative from the task force when they haven't authorized him to come here and speak for we. You've got to figure out how to cut him off at the mic. Commissioner Keene, my esteem for you just went up again. Thank you for adding all three recommendations to your amended motion. I think the point of those will be to start sending a signal to other city departments that they had better start complying with the Sunshine Ordinance. To that extent, it should be a unanimous four-person vote to uphold your motion tonight, sir. I really, really am disturbed by Mr. Pilpel's behavior. I'll be amending that complaint, and I'm hoping, Commissioner Keene, that you will have the wherewithal during the agenda-setting topic tonight to recommend that a public hearing on Mr. Pilpel's SIA violation be expedited and put on your next commission meeting.
Other public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government, and I would like to say I may have to go back to my general public comment and withdraw a couple of things regarding the new members. Very frankly, I think asking a question as to what good it's going to do to do this is rather transparent. What it's supposed to do is get people to follow the law. They all have a responsibility. They all know what the law is. They've known it for more than a dozen years. And yet we repeatedly get in these situations such as this where he was denied due process. Because basically he was denied the records that he needed to present his case at various points, whether it was at the Sunshine Ordinance Task Force, their subcommittees, the Appeals Board, the Planning Commission, or whatever. If I can keep you from having the documents you need to prove your case and to prove something I presented is not correct, then you have interfered with the course of justice. And that's what the Planning Department did, and I have no reason to believe that they are so ignorant of what they do that they didn't realize that was exactly what they were doing. Now, as far as finding Mr. Rahim responsible, he is responsible. No ifs, ands, or buts. If you're the head of a department and you accept $180,000 or $200,000 or whatever salary you get, plus another 40% in benefits, and you take an oath of office to support and defend the Constitution of the United States and that of the state of California, and all of the laws that come therefrom, that's a big responsibility. And you can't then come back later and say, well, because I didn't directly handle this request, I can't be held responsible, is just a complete denial of anything you know about proper management and acceptance of responsibility. And now we find out that Mr. Rahim has as a direct report the individual who is responsible to see that all those other people answered this request properly. And do any of you honestly believe that throughout this entire process, from beginning to end, Mr. Rahim was not kept fully informed of everything that was going on? And that he had every opportunity, if he wanted to say something, to show up at any of these hearings? So he was not denied due process or notice or anything else, unless you want to assume that every single employee he has tells him nothing. And if that's the case, he's got bigger problems than this.
All right, I'll call the motion. All in favor?
Aye.
Aye. Opposed?
Thank you.
Motion is carried
Unanimous vote.
unanimously. Now, there's a second charge in the referral from the Sunshine Task Force, which was a violation of Section 67.29-7A, which was maintaining records in professional and business-like manner. Any commissioners have any comment on?
On that, Mr. Chair, I don't think that we have any evidence of any kind before us as to how they maintain their records, so I'd be hesitant to vote on anything relating to whether or not they maintained their records correctly or preserved them correctly or didn't preserve them correctly. I think the evidence that we had was pretty strong that they didn't comply with turning over the records that they had, but I don't think we have anything in front of us in terms of how they kept their records. So I think in regard to that one, I don't know what the procedure would be. We just
I think it would be that some motion be made to make a finding that that we did not have sufficient evidence to support a finding that there'd been a violation.
I'd so move, Mr. Chair.
Second? Public comment?
Thank you, Commissioner Rennie. So 1 minute my esteem goes up, then it comes right back down. Because the Sunshine Task Force held hearings. They issued an order of determination. It was referred to the Compliance and Amendments Committee. After a while, it came back to the full task force. They issued another order of determination, and they said, look, they didn't keep their records in a business-like manner. What more do you need than to have the complainant show up and testify that he took pictures of blank files? That photograph of a blank file, is that not evidence, Commissioner King? Does the evidence only come from SOTF, or can it come from complainants or from the respondent? Your evidence should be the referral from SOTF that the records were not kept in a business-like manner. End of story.
Commissioners Ray Hartz, Director, San Francisco Open Government. I've been a professional manager for most of my adult life. Started out at 16 doing it. And the bottom line is I'm responsible for keeping the records, and I'm responsible for responding to anything that I'm responsible for responding to. If you look at the evidence then and the testimony you've heard tonight, you only have two choices. Either they're so incompetent that they keep their records in such a hapdash way that this is the response they get. We give you a little here and a little there, and then a month later we give you a CD, and a month after that we give you another one, and then we go looking for this and looking for that. That is the sign of a professional organization or a professional record keeper. If you went into the Internal Revenue Service and they said, oh, well, we need to see some documents to support your deductions, and you said, well, I have a few receipts in a bag over here, and I have a few things over here, and you gave them something one day, and, well, sent them a thing a week later or something else, and whatever, what do you think the IRS would say to you? The bottom line is either they don't keep their records in a professional manner, or they purposely withheld the information. What are the other choices? I mean, I think you're giving them the benefit of the doubt if you say they're not keeping professional records, because the other one is a willful violation. We keep the records in a way that we can't even find them, so that we can, when someone asks for them, simply pretend like, oh, well, we did a good job searching. We just don't know all the damn places that we put the records, so that we can go and search. And we keep some over here, and we keep some over there, and we may think it depends on who you talk to. I heard one thing where the complainant got a letter saying, you have to ask a specific person, which everybody on this commission ought to know is wrong. You can ask any employee of any branch, and they have a responsibility to respond, and if they can't, they have a responsibility to refer you to someone who can. That's specifically written in the ordinance. So, which is it? Were they so unprofessional that they kept their records in a way that they gave the response that they gave, that dragged out over months and months and months and required multiple hearings? Or did they do what I really think they did? They didn't want to give him the information because it would have put a monkey wrench in the works of what they were trying to get through on behalf of somebody, and now they want to hide it. Now, you're intelligent people. Which is it? Are they just really, really bad record keepers, or are they just really, really bad liars?
David Pilpel again, speaking as an individual. At this time, I support the motion. I agree that there is insufficient evidence to find a violation of 29-7 for failure to keep records in a professional and business-like manner. Thanks.
Contradicting that.
No other public comment? Call the motion. All in favor? Aye. Opposed? It's passed unanimously. Turning to
Commissioner
item 4 on the agenda.
I apologize. Just
Sure.
under the regulations, the next step in the process is for the commission to instruct staff to prepare a written order reflecting the commission's findings.
All right.
So you're free to do that if you'd like.
All right. So I would ask that the staff prepare an appropriate order reflecting the findings and the determinations of the commission on agenda item number 3. Item number 4, discussion and possible action on a request for 2 waivers from Campaign and Governmental Conduct Code Section 3.222. Leo Chow, who occupies one of 2 designated architect seats on the Arts Commission, has requested 2 waivers from Section 3.222, which bars members of boards and commissions from entering into contracts with a city where the contract amount exceeds $10,000. The attachments were a waiver request from Mr. Chow, letter from Tom DeCagne and J.D. Beltran, July 23rd, 2014 staff memo, text of Section 3.222, draft resolution, and also, I believe, added to that was an email from the mayor's office in support of the requested waivers. Is Mr. Chow here? Come forward. Good evening.
Good evening, Commissioners.
I wonder if you could state the reasons why you believe we should grant this waiver of the Section 3.222.
Certainly. Let me begin by saying that I fully am supportive and appreciative of the reason for the ordinance in the first place, that the importance of creating separation and preventing any sort of favoritism is, I believe, extremely important to all of us as citizens of San Francisco. So my understanding, as I discussed this with the city attorney's office, was that the provision that allows for a waiver in this case really is, I think, specific to exactly the kind of situation that I have here, which is that as a architect, I and my firm specialize in very large-scale, very complex projects. So, for example, we were the designers of the international terminal at San Francisco. So that's kind of the scale at which we work at. It's a very specialized area of the profession. And so I also believe that San Francisco should have the best, have the opportunity to have the best in design for all of its civic projects. And so I really try to, I see it as an opportunity to try and help out the city in terms of achieving that great design, both in public life as well as in my private practice. So in the public arena, I see that the Arts Commission is really an opportunity for me to bring some of the experience and some of the knowledge that I've gained through my years to bear on reviewing projects. And I take that very seriously, and I really am very passionate about that. At the same time, I think that the city really should benefit from some of the expertise that we have, and as a firm. And so I think that, you know, my goal would be to try to allow for that design excellence to be brought to the firm in both arenas. And in order to do that, I do believe that the separation of what I do for the commission from what we do at the firm needs to be completely separated. And so that does involve recusing myself in all review of these projects or discussions about these projects at the commission level. And then at our firm, because we are a large firm, we have about 240, almost 250 people here in San Francisco. And so the way we would do that is that there are separate individuals from myself, design partners and managing partners, who would be responsible for review and oversight of the project. I'd be completely separate from any involvement of within those projects. In fact, the project that one of the projects that is current project, Moscone Center, is actually being performed in an office space in a separate building, so I don't even see what's going on a day-to-day basis. So that's really, my goal is, again, just to really make sure that I get to continue to serve the city and also have the city benefit from the professional services that my firm could provide.
Commissioner Andrews.
Mr. Chow, thank you. I wanted to talk a little bit about timeline. You've been a commissioner since 2009, is that right?
That's correct.
Yeah. And I was just looking here on on the footnote that it said Commissioner Chow indicates that he was initially unaware of your firm's agreement. And I wanted to find out, one, is there an internal process inside of your firm that would have either a policy or a practice in place where you do kind of check out for conflicts of interest? And we find ourselves here, so we may as well state the fact that there is potentially a perceived conflict of interest. How long had you known about this or your firm know about this?
Sure. So a couple of things, maybe points of clarification. First is I've been a commissioner since 2009, although I've only been a partner at the firm since October of 2013, so relatively new. As far as the conflict, originally my understanding was that there wasn't a conflict because our contract, in fact, is with a nonprofit. So there's a provision that states that nonprofit contracts are exempt. So that's the way I understood it. When the project for almost at the same time that we signed the contract, we began pursuing or considering pursuing the work at San Francisco International. And at that time, I contacted Director DeCaney and asked him to say, I think this would be a potential issue here, at which time he put me in contact with the city attorney's office to discuss it. And it was in the course of that discussion that I became aware that this was, in fact, a conflict or potential conflict. So it was, and that the timeline-wise, the contract was signed in April. I think it was probably middle of May when this conversation started.
Any other question?
No, I don't. I think I have enough.
I guess the thing that concerns me, Mr. Chow, is, and I appreciate, your willingness to serve on a public commission which doesn't pay you any money for the time and effort that you spend, and bring your expertise to it. On the other hand, the purpose of the statute is to avoid not only a real conflict, but the public perceiving that there may be a conflict. And I guess when I think about SOM and how big they are and how much work they do, and so much of it, we're talking millions of dollars with the San Francisco government, and for us to grant you a waiver and say, well, we'll rely on the fact you won't have anything to do with it, but you're still out there to the public's eye of you're an SOM architect who is sitting on the Arts Commission, and I guess it strikes me that there's got to be some very, very special circumstances before we should make a waiver of this statutory provision, which is clearly intended to not only deal with real conflicts, but to give comfort to the citizens of San Francisco that there isn't sort of an old boys network that contracts are going out to companies and partners in those companies are sitting on public commissions, and whatever prestige may accrue to it. I've just got to say, I, for one, start with the position that only in exceptional circumstances, nothing personal about you at all. And I mean, And it's a difficult decision because I appreciate citizens being willing to serve on these commissions. On the other hand, the voters have said they want to keep a separation. So my initial reaction is to look very skeptically about our granting a waiver.
Certainly. May I respond?
Yeah, sure.
Maybe 2 points. The first is that the selection process for these projects is a public, open call for proposals. So there are many firms vying for these projects. They go through a publicly open selection process, all of which can be Sunshine Ordinance and all the records of how the project is, or the project designers are chosen, is open to the public. And then I think, secondly, the fact that I apologize if I overstep here, I'm not an attorney, but my interpretation of the reason why the waiver concept is introduced within the legislation specifically is for individuals where there is specialized knowledge, and it specifically says trades and professions. And my seat that I sit in for the Arts Commission is specifically appointed for architects. So I think that there's a desire for specialized knowledge. So those would be the two things that I would consider as being integrated into the concerns that you're raising.
Chair, this may be a question for the commissioners. I wanted to see if there was some distinguishing feature or with what is before us as compared to the same conversation we had a few months ago. And it was another architect, I believe, that was in front of us seeking a waiver. And what is different, what is similar, and is what Commissioner Chow put forward as just an architect or an architect that represents a firm that does large projects warrant the distinction between what we ruled on a few months ago and what's in front of us today?
Mr. Chair, responding, I wasn't part of the board for that at that time, so I don't have anything that I could add relating to that discussion. But I would agree with Commissioner Rennie, and once again, this is not personal at all. You clearly are an exceptional individual in your profession, and by not having you, the Art Commission is going to lose some real talent. But I can't help but think that just like there are other lawyers out there in terms of my own profession, that there are other architects out there who also have talents and would want to be part of the Art Commission and could be quite helpful just as you are. And the defining thing with me, as with Commissioner Rennie, is the appearance of it in regard to when we're talking about these projects and in regard to a company like yours, a huge company like yours, and the projects that are worked on and what's going on in San Francisco now, we're talking about hundreds of millions of dollars of big projects and everything under scrutiny and everything under criticism, sort of a presumption that somebody out there is stacking the deck for someone, and that's not going to, I'm sure that I know that's not the case in your situation, but that would be the perception by some members of the public. And it's something that the citizens of San Francisco, I think, would not be well served by having that perception. So I think that, regrettably, that I would vote that the waiver should not be granted. I would commend you for your service, just as Commissioner Rennie did. I'm sure you've added quite a bit to architecture and art in San Francisco, and I hope that you're not a stranger to it in the future as a result of this. But I think it's just too important in regard to having this kind of non-appearance of any kind of conflict.
Well, my view is a little bit different, because I do think that with some of these regulations, the city kind of cuts off its nose to spite its face. And, you know, there are any number of extremely large architectural firms in the city. And all of these firms have contracts of one kind or another with the city. I think that's pretty inevitable with the many projects that are underway. So in a way, we're punishing every single employee of any of these architectural firms if they want to serve or do some kind of public service within the city and county of San Francisco, simply because they're employed by SOM or, you know, I don't know the names of all of the other architectural firms, but, you know, Heller, Manus, et cetera, et cetera. So unless you are actually involved in some of these projects that are currently underway, and I would like you to clarify that for me, I see no reason why you shouldn't continue on the Art Commission. I think the issue is whether or not you are directly involved either in the bidding process or even in the architectural process of these existing projects that Skidmore, Owings, and Merrill has currently. So if you could answer, if you could respond to that, I would appreciate it. But otherwise, you know, if you're not involved and you are able to recuse yourself from anything that has to do with the decision on design review for those projects, I would be satisfied with that.
Okay. So my waiver request is for two specific projects, so it's not a blanket general request. The first is Moscone Center, which is a project that we currently have and won through a open request for proposal. The second one is a project for San Francisco Airport, which we understand is about to continue its renovation program. And we think that there are some projects there that we might be able to lend our expertise to. So we don't have those projects. In fact, the RFPs are not out right now. But what I'm trying to do here is be proactive and know that we have a potential conflict there, would have, and so come to you with a request specifically for that one project as well, so that I could assure mechanical engineering and other firms that we're putting together as a team to pursue these projects that we would in fact be able to pursue them.
You're talking about the Moscone Center project?
Moscone, we already have. San Francisco, one of the ones that we're interested in pursuing.
But in terms of Moscone, would the two architects on the current Arts Commission normally be involved with the design review of that project?
As part of the civic design review, there is a committee of 5 of us, including 2 architects. We would normally be involved in that. And I would recuse myself. Typically what we do at the Arts Commission is for a recusal, the commissioner actually steps out of the room completely so that they're not even present during the discussion.
And does another architect stand in for any architect that has recused himself?
No.
So does that put the Art Commission or the Design Review Committee at a disadvantage with the recusal of that architect?
Well, I think part of the reason why we have 5 is so that should a recusal be necessary, we still have sufficient judgment there. But yes, you know.
And in terms of the SFO project, what role, if any, would you have in that?
Again, because of the situation, I would have recused myself at the commission, and then within our firm, I would have no involvement at all. Again,
is that under normal circumstances or simply because you're on the Arts Commission?
Actually, it's because of normal circumstances. There's 3 of us, actually 4 of us, that take care of, who are responsible for the design of projects at the firm. we divide the work up amongst ourselves, and each of us functions completely independently. We're not really aware of, or, frankly, we're all quite busy and not paying attention to what the other ones are doing, other than at a operations and sort of policy and governance level. So day-to-day operations are left to the individuals.
And one more question. Why are you on the Arts Commission to begin with? You've been on it since, what, 2009?
Since 2009. It's something that I found myself to be very extremely passionate about, is that I really feel that the quality of design in the projects of civic buildings really needs to be brought to the highest level possible. These buildings are the public face as institutions for the city. And I think it's very important that for the city as great as San Francisco that we have truly excellent design. And so it's an opportunity for me to contribute my thoughts and critique and work with the project teams that come before us to try to make sure that we are providing the city with the best level of design possible.
Who appointed you to the commission?
Let's see, I was appointed under Mayor Newsom,
Right.
And was reappointed by Mayor Lee.
And is there a term of the service on the commission? 20 years?
Yeah, I believe it's 2 years, 2-year terms.
Your answer to Commissioner Haynes' questions, though, sort of highlights the concerns about the conflict, because when plans from SOM come before the Arts Commission for review, even though you may absent yourself, the other 4 members know that's your company, and you don't like to pick on your friends, and that's really what the problem is that perception. It may be the other 4 can be totally independent and disregard any relationship they have with you, but to the public, particularly somebody who's skeptical of the way in which projects are parceled out and done in San Francisco, it's that perception that I find is why we have the need to make sure that everybody on the commission is independent of any possible prejudice or influence that shouldn't be in the process. Anyway, any other comments?
I just wanted to remind myself and then remind the commission that when we reviewed this same general issue back, and I guess it was in May, with Commissioner Smith, we took a position on the fact that there was just intention to move forward with the bidding process, any future bids that were out. I remember a line of questions that we asked: are you currently seeking an RFP? No. I'm interested in RFPs that may be coming to the city, and we want our firm to be able to be competitive with those. And our decision on that, even on that point of view, where there was not even an existing relationship, we had a ruling on it. So I want us to be mindful of that. And I know we have, I'm not sure if we're going to take these in pieces or 2 different ones, but I think it's important for us to at least revisit what positions we've taken in the past.
Does anybody want to make a motion as to how we should deal with these 2 requests? I think we can deal with them as a package because they relate to the same sort of subject matter.
Yes, I'll, again, reluctantly, because I recognize the talent that's being lost to the Arts Commission here. but I would move that we not approve the waivers.
That's second.
Seconded by Commissioner Andrews. Public comment? Thank you, Mr. Cho.
Commissioners, Ray Hartz, Director, San Francisco Open Government. Usually these cases are issues where a city employee wants to leave and wants a waiver to go to work for a company which is contracted with the department or division that they have been working for. And usually in those cases they identify a clear need for this person to take that position, or why there would be a detriment to the organization not to be able to hire them, so forth. In this particular case, I see nothing in any of the documentation to show that Mr. Chow is irreplaceable. He has been on the Arts Commission for 6 years. That's a pretty good run, 2009 to 2014. I did not hear anything from him saying if I were to leave, the Arts Commission would suffer. In this city, you've all mentioned, I think, that there are dozens of architectural firms and hundreds of architects. So it isn't like we have some sort of we only have 5 architects and we have 5 positions, so if we take him out, they're going to be, left without that expertise. And going back to what several of you mentioned, it is the appearance of conflict. And I taught the University of Hawaii for 14 years. I was involved in a lot of outside counseling and consulting with places like the Office of Hawaiian Affairs and so forth. And one of the things that you realize when you do that kind of work is you become privy to information that is in conflict of the rules. And the simple fact that we rely sometimes on people just being honest is a nice thing to do in a purely theoretical sense. Am I saying that he is not an honest person? No, I'm absolutely not saying that. But what I'm saying is a person in a position where they get information which is beneficial to themselves or to their company or whatever, has a real temptation, and we know that temptation is violated consistently in all forms of government, non-government, so forth, that unless there is a clear reason why he is the only person who can be on this commission, I agree with you that this waiver should be denied. Also, the fact that when he took the position, I would assume being a very intelligent person, he actually sat down and thought about all the conflicts. And I'm kind of surprised that after that many years, this is the very first time any potential conflict has been brought up.
Good evening. Nicole Wheaton from the Mayor's Office. I'm the Mayor's Commission Liaison responsible for finding and locating commissioners to appoint into our mayoral appointed seats. And I did want to just speak to what Mr. Hart said, and which is outlined in my email to the Commission, that it is actually difficult to find the most qualified, competent commissioners who reside within the city and county for a seat that has a mandate attached to it. And I think something that Commissioner Ham pointed out, which was a really good point, with 2 architect seats on this commission, both of which I'll point out have come before you for a waiver, which I think is something that shouldn't be dismissed. With those architect seats, they represent somewhat small architecture and large architecture, and Commissioner Ham made a good point that many of those large firms do contract with the city and county, and so to dismiss any single person who works at a large firm simply because of that, not taking into consideration Commissioner Chow's ability in this instance to wall himself off from those conflicts, it does deprive a large portion of San Francisco's citizens from serving on this commission in this instance, and I think it actually does a disservice to the people of the city and county to not have that voice represented on the commission. So I would say that we're charged in the mayor's office with appointing diverse appointees to all of our commissions. I would say large and small architects are part of that, and so I would strongly urge you to support his waiver requests. I think it would be a disservice to the city to not have him continue to serve, and I would argue that it's very difficult for the mayor to fill that seat in a manner that would not present a conflict for that commissioner. And I'm happy to answer any questions.
Thank you.
Are we taking questions now, or we have to wait for everybody? Ms. Wheaton, yeah, so were you aware of Commissioner Smith's waiver?
His waiver request? Yes, I was made aware of it, yeah.
And you're here in support of Commissioner Chow. I was wondering what your position was for Commissioner Smith, if you had a thought or a position.
Yeah, I think with Commissioner Smith, first, I know it was somewhat of a different type of waiver. It was a blanket waiver, not a case-by-case basis. I think Commissioner Smith, he serves as the director of his firm, and he has the ability to decide on behalf of his firm what projects he can take and cannot take, and the financial implications of that. I think with Commissioner Chow being one of 5 members in leadership at his firm, that's not necessarily apples to apples. So I think it does present a very different case in this instance.
This may be a question that you can't answer or too difficult to answer. Was a request made by Commissioner Smith to write a letter of support or endorsement? And would you have, or could you have, or would you?
A request was not made, and I was not made aware of that waiver request. We very much appreciate Commissioner Smith's service on the Arts Commission, and we recently reappointed him, which I think shows that we believe his service benefits the city and county and the arts communities. So I would have recommended to the mayor that we do submit a letter in support of his waiver. Obviously, keeping in mind there have to be, I think, processes put in place similar to those outlined by Commissioner Chow that would prevent real conflicts from occurring.
Good evening, Commissioners. Tom DeCaney, Director of Cultural Affairs with the San Francisco Arts Commission. Thank you very much for your consideration of these 2 waiver requests. On behalf of the President of our Commission, J.D. Beltran, I'm wanting to encourage support of these waiver requests. Commissioner Chow has served since my 2.5-year tenure, not just as the architect on the Civic Design Review Committee, but he's also a member of the Executive Committee. He also served in the search for my role and is a key leadership position. And I do think the challenge to replace a significant leader in the commission, given the population of San Francisco, given that then narrowing it down to architects that reside in the city of San Francisco, and then given that we would be precluding any architect who would ever work with the city from their service, does, I think, pose a challenge in looking to replace a high-quality commissioner. I want to point out that Commissioner Chow, when he believed the nonprofit waiver request was a valid excuse for him to just simply recuse himself and not pursue this waiver request. So the Moscone contract, as he mentioned, is with a nonprofit. And we have a standard practice of grants to a number of nonprofits where commissioners regularly recuse themselves and step out of the room. Commissioner Chow immediately identified that conflict. He recused himself from any conversations, has left the room, and I think has demonstrated his ability to manage conflicts of interest, both real and perceived, with appropriate action. In the case of Commissioner Smith's waiver request, which was brought forward, that was a blanket waiver request that would not approved, he would not have had to resign from the commission. So it was kind of a different approach where he was looking to expand his work. In this instance, we would be losing Commissioner Chow's service, and we would have a vacancy that would begin immediately, is my understanding, and would require that vacancy until we could find somebody to serve in that architect seat. So I'm happy to answer any questions about how we might manage the conflict of interest should you decide that it was possible to pass these waiver requests. But I do think, given the confines in the law, that the fact that these are narrow, specific projects that are now being heard here on public record have and would be identified before the Commission as standing conflicts of interest. It would be on par with other conflicts of interest that commissioners manage in relationship to nonprofit grantees, just in the fact, and I guess my final point is that we also want an architect that is knowledgeable of the city. So by preventing them from working with the city and county of San Francisco, it does mean that we would be preventing us from finding a commissioner that might understand the nuances of working with the city. And I do think Commissioner Chow brings that expertise in terms of managing timelines and project budgets that are city-bound. So that skill set of a commissioner that understands the city workings of city architecture, it becomes, I could see, a great challenge in replacing that skill set as well. So I'm happy to answer any questions, and I do appreciate your consideration this evening.
David Pilpel again, and again I'm speaking as an individual. I do not know Commissioner Chow. I just think in general on waiver requests, in this case I support the motion to deny the request. My understanding of this seat is that it's simply a licensed architect. It's not specific as to larger or small firm. It appears to me that another individual could be found in the city who's either a small firm architect or merely does private projects in the city or elsewhere, or public projects not in San Francisco. And I think that where we can avoid recusal and have full participation of members on all matters before them, that should be encouraged. And knowing that there's a potential conflict or issue of influence, that should be avoided and another individual found. Unfortunately, if that, in this case, works against the commissioner, I'm sorry, and so be it. So that's kind of my thinking. Thanks.
All right, I would call the motion. All those in favor, say aye. Aye.
Aye.
Opposed?
Opposed.
Record should reflect that the request for the granting of the waiver was denied 3-1, one opposing, and staff will prepare the necessary papers to reflect that decision.
Yeah.
All right. Where's my agenda? Somewhere around here. All right. Number 4 is discussion and possible action regarding the adoption of draft regulations related to the Lobbyist Ordinance and to new requirements for permit consultants and developers of major city real estate projects. These regulations are intended to interpret and otherwise implement the Lobbyist Ordinance, including recent amendments effective July 26, 2014, in the new permit consultant and developer requirement by requiring guidance with respect to reporting requirements, lobbying contacts, and lobbyist fundraising, among other things. Attachments to July 23rd, 2014 staff memo, draft regulations, recent legislative changes to campaign and governmental conduct code. It'd be my suggestion, the draft covers all of the proposed changes that the Commission deal with the entire set of draft, of the draft prior to public comment as to any comments that the commissioners may have as to any of the proposed draft regulations. And let me say at the outset, I want to commend the staff for, I think, an admirable job of carrying out what you state at the very beginning that the implementing regulation shall be construed in a manner that provides for the greatest disclosure of lobbyist activities in the city of county. I think you've done an admirable job. I had, as far as I was concerned, I had only one question or comment on example number 2 on page 2 under regulation 2.1061, contacts, use of intermediaries, where you say the staff members do not state or otherwise. Example 2, paid representatives of a real estate developer meet with staff at the planning department to discuss possible modifications to the draft environmental impact report for the developer's project. The staff members do not state or otherwise indicate, and the representatives have no reason to believe that they will have the substance of their conversation conveyed to either the planning director or the zoning administrator. The representatives have not made a lobbying contact. I guess the question I have is that why isn't it assumed when a lobbyist contacts a staff at the planning department that it's doing so seeking to impact whatever the planning department has issued? I mean, it just seems to me they shouldn't have to say, are you going to tell this to your boss?
Thank you, Commissioner Rennie. Jesse Minardi, Deputy Executive Director. Yeah, this was an example. We talked with 2 things I should say about this. This is in response. This example was drafted in response to concerns primarily from the attorney community about showing up at the Planning Commission and whether that was sort of the practice of law, which is actually a second sort of exemption, as you know. We went and we talked with folks, in particular attorneys working for the city attorney's office, for the planning department, and folks at planning in terms of the mechanics of how this might work if an attorney shows up and is talking with a staffer regarding an EIR or another sort of environmental declaration, let's say, finding. And what we learned is, based on what we heard from planning folks, is that, you know, there may be a lot of back and forth with staff regarding EIRs, other environmental findings that don't ultimately, the report itself obviously might make its way up there, but the actual conversation and the attribution of that conversation doesn't make its way sort of up to the department head or the commissioners. And so we thought it was reasonable to sort of draw the line there and say, hey, you know, to the extent you're talking with staff who are not city officers, you're generally trying to influence it, but ultimately there will be other decisions that, you know, likelihood there's going to be lobbying on those decisions too. We can draw the line there, and we can say if the staff does not indicate, we're going to take what you said, attribute to you, pass it up the line. It's not a contact. I don't know if that answers your question.
It does, but it raises the concern that I have. Sure. When I see it is that so much of the, if we're talking about the planning process, so much of it is talking to the staff people and trying to convince them that what they're proposing, you should do something else or you should do that, and to say that that's not a contact when the end result may well be that the staff accepts and recommends that. But yet there will be nothing in the public record that the staff made that decision based at least in part on this individual, whether it's an attorney or a consultant or whatever it is, went to the staff and said, here's the problem, here's what we need to do, and, you know, I mean, that's the whole evil, it seems to me, that you're trying to at least let the public know that John Doe has gone down there on behalf of the developer to try and get the EIR adjusted or do something else in the planning process. So I'm troubled by example 2.
Okay. I certainly thank you for the comments. I certainly understand that, and One thing I would say is, and this is based on my understanding, speaking with the regulated community and the planning department, is that generally the larger projects where there, let's say, perhaps is a greater interest in public disclosure, that the contacts with John Ram, let's say, they're going to be happening and they're going to be reported. So there is going to be this sort of distinction between, in other words, this may not exempt out that many folks, but your concern is real. Your concern is real.
I mean, my guess would be that the most important contacts are at that lower level before it ever gets to the planning director.
So, Deputy City Attorney Andrew Shen, just to add a little bit more on this example, because I think it illustrates an important point about the Lobbyist Ordinance and its intended reach. So first of all, the Lobbyist Ordinance, as it's currently conceived of, only addresses contacts between lobbyists or potential lobbyists and city officers. So sort of the highest levels of city government, not necessarily any single staff person. You may quibble with that approach, but that's the general approach of the Lobbyist Ordinance. So not every contact with a city staff person automatically becomes a lobbying contact or something that sort of converts a person into a lobbyist. And so I think that's why this example is helpful, because it illustrates how in many instances a contact with a staff person wouldn't necessarily constitute a lobbyist contact. A second point that I would add as well, and I think the Commission is certainly going to get into this issue much more probably at a later date, is that a lot of the action on these recent changes obviously concerns land use. And so in addition to the Lobbyist Ordinance, some of the recent changes deal with permit consulting services. And I think we'll probably see that a lot of contacts, to the extent this is your primary concern, with planning staff on a whole range of planning projects will be covered by that separate provision. So not necessarily by the Lobbyist Ordinance, but a lot of that I think will be picked up by other sections of this recent legislation.
But I thought as I read your regulations that you are picking up as contacts talking to the supervisor's aides. That's a contact. That's not a city official.
Right, and I don't want to speak too much for Jesse, obviously, but I think there is at least a substantial difference in, not in kind, but certainly certain substantial difference in terms of degree. I mean, in a supervisor's office, there's currently generally only 3 aides, 3 full-time aides working with a single supervisor. The planning department, I don't have a specific number, but is significantly larger. I mean, I imagine that there are hundreds of employees of the planning department. And I think this example is intended to illustrate that not any single conversation you have with one of those hundreds of planning department employees is necessarily going to get to John Ram's ears or the ears of a planning commissioner. I think that's right. But that's...
No. Thank you.
Any other comments by the commissioners? Anyone want to make a motion that we adopt the proposed regulations based upon the draft that was provided to us?
I'll move it, Mr. Chair. I have also found the staff's analysis of this to be very helpful. So thank you. Good job. Thank you very much. Covers a lot of areas. I'm sure that in the future we'll probably be looking back and saying, why did we do that? Because there's so much here. And just generally looking over what's a vast array of many possible difficulties that have to be met, I think it's fairly comprehensive, and I would move it.
Second. Commissioner Andrews seconds the motion.
I'm sorry, Mr. Chair. I just wanted to say that there are a couple of tiny little edits that are sort of non-substantive in nature, that are just sort of grammatical changes. So I guess we could either just read them really quickly. So page 1, line 8, instead of referencing an entity, we'd reference a person, because that's for a lobbyist employer, that's how we designated them, as a person, not an entity, so just for consistency's sake.
Okay.
Page 3, line 17, multiple copies. This indicates that multiple copies of the same communication sent, and we would say from the same individual to the same officer shall constitute only one contact. Page 5, line 3, the determination what constitutes the practice of law shall be based on an analysis. And then same page, line 13, the attorney and the CEO, we would add the attorney and the CEO have each made a contact, specifying that the CEO has made a contact as well. And I think that's it. That's it.
So with those,
pardon me, Commissioners,
changes,
for public comment on this issue.
I just want to get the motion.
Okay.
Then we will.
We were concerned that you were going to pass the regulation without public comment.
But as to the,
I'll accept those changes.
okay. All right, now I'll have public comment on the motion.
So, sorry about the interruption, guys. Good evening. My name is Jonathan Minster. I'm an associate attorney at the Sutton Law Firm. And as you guys hopefully have in front of you, we recently, this afternoon, submitted a letter to you with respect to a few comments we had on the proposed regulations. And we just wanted to bring those to your attention before any decision or action is taken. I would like specifically to speak to the issue regarding the actual way that lobbyist fundraising activity will be reported. Right now, the recommendation by staff and the proposed regulation states that there should be an itemization, of each contributor of over $100 that is given as a result of the lobbyist's fundraising appeal. We would suggest that, as we wrote in our letter, that the approach be taken, not be the approach taken, but rather the LA and San Diego standard be used, in which instead of itemizing each individual contributor, there's the total number given to each candidate is stated. So if you do a fundraising event and you were responsible for 10 people contributing $500, the report will just show one $5,000 fundraising activity from the lobbyist on the report to the specific candidate. The reason we believe this should be done is that we believe it effectuates the public policy and the intent of the law without having an overly burdensome reporting requirements. The real intent of the law, I believe, is to ensure that the public is aware of any possible undue influence that may occur between a lobbyist and an office holder or a candidate. And that will be clearly shown on a report that says a total sum of money. Even it would actually maybe be more helpful to have the total sum as opposed to an itemization of each contributor on the report. In addition, the reports of the candidate will already show every contribution that comes in over $100. So if the public wants to know which contributor is giving to which candidate, that is information they already have. Also, it can create time-consuming and unnecessary reporting requirements on a lobbyist. A lobbyist will have to know each and every person that contributed on their behalf, which may be a hard standard to go by, which will probably be discussed later. They will have to get the names, addresses, amounts, the occupations of every individual contributor, which may be very difficult. And that'll also maybe create a situation where a campaign report of a candidate will say one thing, but on the other hand, a campaign report or the lobbyist report will say something different. The last thing I want to address in the time I have remaining is that it might also unnecessarily or unwillingly tie a contributor to a lobbyist, and they'll be disclosed on the lobbyist report without having, simply by getting an email from a lobbyist based on this very broad standard of when a lobbyist fundraising activity is disclosable. So for that reason, we hope that you guys consider adopting the LA and San Diego approach, whereas as opposed to itemizing each individual contributor, it'll just have one large number on the report saying from which lobbyist to which candidate. Thank you, guys.
Thank you.
Good evening, Commissioners. Jim Sutton, also with the Sutton Law Firm, and also have a different comment about the same proposed regulation regarding the disclosure of fundraising activities by lobbyists. We too commend the staff on confronting so many kind of vague and ambiguous provisions of the lobbying law all at one time and really doing a yeoman's job on coming up with some more concrete and clearer guidelines for the lobbyists that we know we represent who struggle with filling out these forms on a monthly basis. But we do have a concern with the proposed regulation that would dramatically change how lobbyists have to disclose the fundraising that they do on behalf of city candidates and ballot measures. Whereas right now, the law is they have to disclose any contributions they deliver, any contributions they arrange, any contributions they act as the agent for. The proposed regulation kind of comes up with an entirely new legal standard, this know or have reason to know standard, which is used in Los Angeles, is used in some model laws, but is not used in San Francisco laws. And we have concerns that this new standard is really much more unworkable and really vaguer than even the current law, although we agree the current law on what fundraising activities lobbyists have to disclose certainly is in need of some clarification. So I always like to use this example of why it is really unworkable to expect lobbyists to disclose contributions which they, quote, have reason to know were made because of their lobbying, because of their fundraising efforts. I, like I'm certain all of you, will oftentimes get invitations from elected officials and candidates to go to events. So, for instance, with the supervisor in my district who I have given a contribution to before, chances are I'm going to give a contribution to him or her when he's running again this year. Because I've given before, because I've gotten to know him, I might even get a phone call solicitation from that supervisor asking me to make a contribution. Then, of course, as I'm certain happens to you, one, if not several of my neighbors will have house parties for the supervisor, so they get invited to those. But then I also get an invitation from a lobbyist to go to an event that the lobbyist is co-hosting or might even be in the lobbyist's office. When I go online and I make that contribution to that supervisor, according to the new reg, because I got that invitation from the lobbyist has to put my name, my address on the lobbyist report saying that that's why I gave, when that just may or may not be the case. Did I give because I gave before? Did I give because my neighbors invited me? Did I give because the candidate called me? And the kind of vague have reason to know standard, and I could go on with all the different scenarios where it just would not be appropriate. So as mentioned in our letter, and we apologize for the last minute nature of the letter, but the staff memo that came out late last week kind of changed the proposal. Again, we urge, as the prior speaker said, the San Diego approach. San Diego did a very thoughtful, lengthy analysis of this issue of fundraising disclosure and decided it was only appropriate to require a lobbyist to disclose contributions they fundraised if they took credit to the candidate one way or the other. If the candidate knew that they had raised the money. If the candidate doesn't know that the lobbyist raised the money, there's simply no public policy reason to require the lobbyist to disclose the contributions. So we request that
Time's up.
Yeah, thank you.
Okay, thank you.
Good evening, Commissioners. My name is Ryan Patterson, and I'm a land use attorney here in the city. I'm here to take this opportunity to introduce to you a new association in the city, the San Francisco Permit San Francisco Permit Professionals Association. This is a new organization that has been formed following the passage of the recent changes to the Lobbying Ordinance dealing with permit consulting services. We consist of land use attorneys, permit expediters, architects, code consultants, other design professionals, and we have come together to, in part, interface with this body to help you with implementing these new laws, to help with designing new rules as part of this process. And I want to thank staff for their outreach so far and say that we look forward to working with you in the future. Thank you very much.
Commissioners Ray Hartz, Director, San Francisco Government. There's an old expression, marry in haste, repent at leisure. And I think that's what we have here in the case of a very, very complicated law. Many of you have mentioned it. And all of a sudden, this seems to be this rush to get this done, even though most of you, I think, have admitted that you really aren't fully conversant with all that's in here. Now, I don't see any reason why there is this immediate need to pass this thing when you yourselves, as Commissioner Keene mentioned, will ultimately end up having to deal with the outfall when you realize there were things that were not covered or should have been covered or were covered and covered incorrectly going forward. Now, the second thing I would like to say is, number one, this memo from the Sutton Law Firm should not even be considered in this discussion. The Sunshine Ordinance requires that anything that's going to be included in the discussion or deliberations has to be presented to the public, and this is dated today. It was not on your website. I did not get my package from the Ethics Commission today, so I had to review all the documents online. This was not online. Obviously, it couldn't be. And as a result, it is illegal to have it introduced here when members of the public had absolutely no opportunity to look at it and consider whether or not they would want to attend this meeting, and that's what the ordinance requires, that everything that's going to be considered be available so that a person of reasonable intelligence can decide whether he or she should attend the meeting, and if so, what they would have to say. So including this at the last minute is a violation of the Sunshine Ordinance and of the Brown Act, and as a result shouldn't be included. Now, the other thing I'd like to mention as sort of reflective of this is we're talking about lobbyists meeting in private with employees of the city. And we can sit and have discussions about levels or all this other stuff. Why are they having private meetings with these people anyway? Why don't they submit a memorandum to explain all their ideas so that members of the public can put a public records request in and see what they're arguing so that they can see or figure out what might be a countervailing argument? I don't see any real reason why there should be private conferences. Citizens don't get private conferences with these folks. Why should the lobbyist firms get them? I know they want it because they make money on it. If they can convince somebody to buy a contract or do what their client wants, then they come out ahead. But where does the public come out? They don't know what's being discussed, by whom, when, and the simple fact is many of the employees will make recommendations to the senior officials we're talking about in the ordinance, which they will do what you do with staff, which is rely on it without looking any further. And as a result, the ultimate outcome will be the lobbyist has an influence over these people that are covered by the ordinance, whether it was intended or not.
Thank you.
Good evening, Commissioners. Anita Mayo from the law firm of Pillsbury, Winthrop, Shaw, Pittman. Please excuse my voice. I have a cold, and I can't read as quickly as I would like, so please bear with me. Number one, determining the number of contacts. Based on prior rules issued by the FPPC, when the contacts test was used to determine an individual's status as a lobbyist under state law, it would be less burdensome, simpler, and easier to administer San Francisco's law if the determination of the number of contacts needed to qualify as a lobbyist was based on the number of officers contacted and not the number of issues discussed with city officers. It appears excessive to base the number of contacts in a single meeting on the number of issues an individual attempted to influence during that meeting. Staff has pointed out that such a regulation would be incompatible with the Commission's online reporting system, but my proposal is concerned with qualification as a lobbyist and not the reporting requirement. Determining how to count contacts with respect to qualification as a lobbyist should not have any impact on the online reporting system. Once an individual qualifies as a lobbyist, then they would be required to separately disclose each matter discussed with the city officer. To the practice of law regulation. I recommend adding a third example to the regulations to clarify that practicing law involves more than just litigation. The only example in the proposed regulation of a communication by an attorney that does not result in a contact is in the context of litigation. It would be extremely helpful to the regulated community if a non-litigation example was provided. For example, you have an attorney represents a developer who plans to build a major housing complex in the city. Before the developer can obtain the necessary permits for the project from the Planning Commission, the developer must comply with the various legal requirements imposed by CEQA. The attorney provides legal advice to the developer about how to comply with the various CEQA requirements. The attorney and the developer must meet periodically with the executive director of the planning department for the purpose of discussing the various legal requirements imposed by CEQA and the developer's progress in compliance therewith. Neither the attorney nor the developer attempts to influence the executive director regarding any local legislative or administrative action. The attorney has not made a contact. 3, contributions disclosure. This regulation as drafted will impose a tremendous burden on lobbyists who would have to track all of their fundraising activities and determine whether contribution checks were actually written as a result of the fundraising activities. By simply requesting that a person make a contribution, invite a person to a fundraiser, supply names to be used for invitations, permit one's name to appear in the solicitation, pay for 20% of the cost, or hire a person to conduct a fundraiser, the lobbyists would be required to track down and disclose all contributions resulting from the foregoing. And finally, permit consulting services. The term permit consulting services is broadly defined to mean any contact with the Department of Building Inspection and Entertainment Commission Planning Department or the Department of Public Works to help a permit applicant obtain a permit. This definition is so broadly defined that it could apply to an attorney who, as part of his or her legal services, assists a client in obtaining a permit. To avoid this result, a regulation could be added to clarify that permit consulting services does not include contacts made by a licensed California attorney engaged solely in the practice of law. Thank you.
Thank you. Thank you.
David Pilpel again, speaking as an individual. First, I want to commend staff for the good work on this and encourage you to adopt the regs either in whole or as amended. The law took effect in the past few days, and there are no implementing regulations. Adopting regulations tonight would then go into effect in 60 days unless the Board of Supervisors intervenes. These are very good. These are high qualities. These are excellent, but there may still be some things that need to get caught or fixed. You have the ability to change regulations in the future, but I think adopting regulations tonight is a good first step in implementing the amendments covered by the law. To address a couple of points, I don't disagree with having further clarification about the practice of law regulation. Although I think in general this is pretty clear. I did want to speak about Regulation 2.110-4, the contributions. On page 7, you might choose, I'm not really recommending it, but you might choose on line 4 to strike the words "or has reason to know." So it would simply be that the lobbyist knows were raised as a result of fundraising activity. That would perhaps clarify some concerns about that. But either way, I wanted to speak on page 8, example number 3 at the top there, line 5. I would reword that to say the lobbyist must disclose the $5,000 in contributions collected at the event, and then add a new sentence, and I'll read it quickly. I can read it back if you need to. If the candidate's campaign informs the lobbyist of the 5 other contributions, then the lobbyist must disclose those contributions as well. The intent there is that, again, it's not, has reason to know, but if the lobbyist actually knows the contributions were made as a result of their fundraising activity, they should disclose. And I do disagree with the prior public comment about aggregating the contributions made. The law clearly states that for each contribution, certain information is required to be disclosed by the lobbyist. Again, in general, I support this. I think staff has done a great job. I can answer any questions, and otherwise I support the motion before you. Also, you have, I believe, included in that motion renumbering the prior regulations. I assume that's captured. Thanks.
Any other public comments? addressing one of the reasons why we are asked to adopt these regulations now is that the new statute has gone into effect, and the reporting requirements, there needs some clarification for the lobbyist community, with the understanding that obviously if in implementation the staff and we decide there needs some amendments at some later date, but on the face they provide guidance for the implementation of the statute. There are no comments. Should we take a vote on the adopting the regulations, the draft regulations as proposed? All those in favor?
Aye.
Aye. Opposed? All right, the regulations are adopted unanimously, and the staff will put them in final form for implementation. As I understand it, what is 60 days before they actually
transfer them to the Board of Supervisors.
Yeah, go to the supervisors. All right. Item number 6 on the agenda is discussion and possible action on the minutes of the Commission's meeting of June 23rd, 2014. Commissioner Keen?
Yes, Mr. Chair, I don't have any specific comment in regard to the minutes. I just want to explain and apologize for my absence last time. It is an unexcused absence, and it should remain an unexcused absence because of my own kind of not negligence, but I had thought that when I came on the commission, for some reason I had in my mind, all of our meetings were on the last Monday of the month, and they all had been until last month when we had 5 Mondays. And then I learned to my horror the day after the 4th Monday that our meetings are not on the last Monday of the month, but they're on the 4th Monday of the month. So I wanted to be here. I was looking forward to be here. In fact, I apologize for having saddled all of you with one of the main agenda items, which was put on for me to have some questions about, hold forth and pontificate about, and I wasn't here, and the rest of you had to sort of labor through it. But I watched the proceedings and wish I had been here, and again, I apologize for my absence. It won't happen again.
And may I say,
Thank you very much.
Someone want to move the adoption of the minutes?
so moved.
All right, second?
Second.
All right. All those in favor?
Public comment?
Oh, public comment, I'm sorry, yes.
Commissioners, Ray Hartz, Director, San Francisco Open Government, and hold on to your hats. I'm going to pay you a compliment. These minutes are an improvement over what they have traditionally been. There are at least 3 or 4 lines about every person who got up to speak. Typically in the past, it was basically they got up to speak about some vague comment. So I appreciate the fact that the effort has been made to include the public and their comments in the minutes. You notice there are a number of my 150-word summaries, and that was something I've been fighting for 6 years, for the simple fact that after attending multiple Library Commission meetings over a period of 2 or 3 years, I found that the comments that I made, which were in any way negative or critical of their operation, were edited out. And sometimes the comments that I made were actually changed to the opposite of what I said. One in particular was so bad, I said, I understand why you put this in here. You want people to read it and think I'm a blithering idiot, because it makes absolutely no sense. That being said, The minutes are the official record of any public meeting. And it is unfortunate in my experience with a lot of the boards and commissions in this city that they desire to keep certain things out of the official record so that at a later date they have plausible deniability to indicate that nobody raised this issue before them. Mr. James Chafee spent 30 years plus going to the Library Commission meeting, questioning the financial dealings of the Friends of the Library. I've told you this before numerous times. Between 2000 and 2013, they expended $60 million raised in the name of the library, and yet neither the city librarian nor any of the Library Commission members or the commission as a whole have any idea where most of that money went. They have simply accepted blindly anything that the Friends told them. And when it really comes down to it, Mr. Herrera spent 2 years withholding public records, violating the Sunshine Ordinance multiple times, which were also prima facie case or evidence that he violated the California Public Records Act. He did this for a couple reasons. One, to hide the fact that he was making no effort to see where that money was going, to hide the fact that he was coming to public meetings and lying to both the members of the Library Commission and to the public about the fact, saying that everything was on track when he had no idea what it was. He wanted to hide the fact that he was taking thousands of dollars from this group every year, lying about it, denying it, and filing on his statement of economic interest. He got nothing, and in turn looking the other way. I call it the you don't tell and we won't ask policy about where that money went. And getting it in the minutes was the official. Please, you let Mr. Sutton go on for at least a minute and a half beyond his. I would appreciate you not kidding me at 3 minutes.
You were telling me to cut him off.
I was, but you didn't, did you?
David Pilpel, speaking as an individual. I provided to staff some minor corrections to the minutes, non-substantive, and I'm also not sure under the Office of the City Attorney if Josh wanted to be Josh or Joshua, but they're non-substantive and perhaps you'll consider them. Thanks.
All those in favor? Aye. Opposed? Minutes will be adopted as written. Discussion of the Executive Director's Report.
Okay. I don't have any highlights today. We are in a new fiscal year, obviously, so the report reflects that. And if you didn't get my message earlier, I just wanted to point out that today the Court of Appeal First District published its opinion in the lawsuit and found unanimously in favor of the Ethics Commission.
Jack, you submitted a budget for 4.7. It came out of the mayor's office with 4.5. Through an add-back process of Board of Soups, you got $50,000, which is great for some advocacy, which leaves a delta of just about $132K. And I was wondering what were those expenditures, and then what adjustments did you need to make in?
Well, last year we received a more sizable add-back with the idea at the time that we were going to hire a third investigator with that money. But there was no guarantee at any point that I could get that the funding would continue. And I was reluctant to hire someone in the middle of the fiscal year that would have worked for 6 months in a job that has a steep learning curve and then have to let them go. And in fact, that's what happened because the funding wasn't continued. Some of the money that we had anticipated to use for that position wasn't used last year.
Any public comment on?
Commissioners, Ray Hartz, Director, San Francisco Open Government. As I promised you at the last meeting, as this comes up every year, every meeting, I'm going to be talking about a different area. The one I would like to talk to about is area number 2, investigation and enforcement reports, where it says at the bottom, Sunshine Ordinance, number of complaints 2, and that is the total extent of the mention of the Sunshine Ordinance. Look on your website. Part of your responsibility is enforcing the Sunshine Ordinance, and yet every time the Sunshine Task Force refers you a complaint, you sit here and kibitz and kvetch about the fact that this is not clear and that's not clear, so when are you going to do something about it?
We just did.
No, with all due respect, Commissioner Kane, this discussion has been going on for more than 5 years, the discussion about who gets put on the complaint. I put the department head in each and every case, and I've had the task force actually go back and take that off. The reason was they went through 2 years of discussion saying, well, we're the Ethics Commission, and according to the Sunshine Ordinance, the only people we can discipline are department heads and elected officials. So if you got a complaint and it was against one of the line employees, your immediate response from the staff was, we can't do anything. So these things go back and forth, and you know, you can say, you know, the task force doesn't know what it's doing, but every single time the task force sends you a recommendation, you find, or the staff finds some reason to find it at fault. And if you really do think that it's at fault, and you acknowledge the fact that part of your responsibilities as a body is the implementation and the enforcement of the Sunshine Ordinance, then I would think that there would be a moral imperative for you to do something, to get together with the task force and come down with something meaningful where you can actually do something rather than having these pointless arguments about whether or not they charged the right person or they crossed the right T or dotted the right I. The intention of that ordinance, the Sunshine Ordinance, is to let people, number one, go to public meetings and speak. And I have been to the Police Commission and was told by the president of the Police Commission, you're not allowed to talk about certain things. I was told the same thing by the president of the Arts Commission. I was told the same thing by the president of the Library Commission. And they all knew it wasn't true. But they did it anyway. Why? Because they got away with it because they knew it would go to the task force. And for some reason, you want people to believe that the Sunshine Ordinance Task Force is a bunch of nincompoops that doesn't know what they're doing, and you're just oh so much cleverer than they are. Because you can find some way of saying that there was something they did in some way that made it wrong, and you're unwilling to do anything to correct the situation, and there's never anything on this report that indicates you ever will.
David Pilpel again, speaking as an individual. The report is good, comprehensive as usual. I think it would be helpful for the next few months up to the November election to include a category here for public financing. I believe there's only one candidate who's qualified, but I think reporting on payments under the public finance program would serve the public interest. And if there's anything else to report about campaign disclosure for November, I would anticipate a lot of activity both for candidates but also ballot measures. It's likely that there'll be 12 measures on the ballot. We haven't seen a ballot that big in a while. And they'll be pretty highly contested. So if there's any reporting that you can provide here in a summary fashion in addition to what's on the website, the dashboards, all of that, that would be helpful. Thanks very much.
All right, turning to agenda item number 8, items for future meetings. Commissioners have any items that they would propose for a future agenda?
Well, I'm a newer commissioner, so hearing from the public how often we've talked about the commission and the Sunshine Ordinance Task Force has talked about this referral process. I'm wondering if we just can't have a conversation about it and see if we can get to the bottom of it, because in less than 6 months we've had this issue come up twice, and I feel like we never get to the actual substantive component of what is being brought before us because we're busy trying to figure out who to attribute it to, the violation.
If I could, unfortunately, Chairperson Herr isn't here, but he would indicate we had talked about possibly doing that, and he had indicated he would schedule something for this before the end of this year. We would have that discussion.
Is it possible for us to have a joint meeting with the Sunshine Ordinance Task Force?
It's been done, but they're difficult to schedule.
Could you try?
Of course.
I speak for myself. I don't know whether the other my colleagues who would also be in favor of that.
Well, we have had joint meetings with them. I certainly wouldn't oppose the idea of having another to see whether we can smooth out some of the problems. I guess one of the questions I had, though, a lot of the procedural things that we deal with, I would assume that the city attorney who's advising the Sunshine Ordinance Task Force is dealing with those problems.
Well, we heard tonight that whoever that person is.
Well, we don't know. We got hearsay about it.
Well, the hearsay indicated that the advice that was given was not the greatest advice in the world.
I guess I could ask the city attorney, do you think it would be beneficial to have a meeting with the
You weren't here when
council?
I apologize, I wasn't here. We're here for the enforcement.
With the council who is assigned by the city attorney's office to advise the Sunshine Ordinance Task Force, meeting with that representative to find out. We've had 2 cases in the last few months that have come up where the Sunshine Task Force has charged the department head, even though in the proceedings the department head was never named, but he gets named, or she gets named in the referral up to us. And then the question comes, well, what's the due process? The department head's never had a chance to respond to it. All of the people who have been responding are people below them, and the argument is made with some merit that the department head is responsible for the people working for him. But insofar as the dealing with the task force has never confronted that issue and said, we're making a finding against the department head for these reasons. Just simply finds that there's been a violation and then names the department head at the end of the game, not at the beginning. And so what I think Commissioner Andrews and we're talking about is there some way that we can smooth out so that we don't have the procedural problems to deal with, but we're dealing with the substance of the complaint?
Right. So, Deputy City Attorney Andrew Shen, so was it, and I wasn't here for tonight's Sunshine referral, but was it represented during that matter that the Deputy City Attorney advisor of the task force had weighed in on that issue?
It was represented that the Deputy City Attorney, at the time with the task force, advised the task force to name the particular underlings in the department as being the responsible ones for the violation. And that's what they did. And I see in the language itself of the ordinance, it says specifically that the underlings cannot be held to be the responsible parties. It says that the responsible party is the department head. So then at some point it's understood after they've done this that, oh, well, we should really name the department head, and then the representatives of that department come here before us and say, you're violating all sorts of due process. Our department head is just being named now at this stage of the proceedings after the task force has already made a finding of the violation relating to those underlings, and he was never named. So we had that twice. We dealt with it tonight, but the last time we had to punt it. We shouldn't have, but we did.
Right, certainly. So it sounds like that's been an issue that's come up several times, and certainly in conjunction with hopefully a future agenda item on this issue, I'm happy to help coordinate within my office and get to the bottom of this. I'm certainly happy to do that whenever this is calendared.
Good.
Yeah, I would recommend that we consider putting how the staff wants to, how we want to address the agenda item, but you know what the problem is that we want to try and resolve, and see what's the most sensible way to resolve it, and put it on the agenda item and get public comment on it.
Yes.
And get comment from the Sunshine Task Force. All right. All right. Is there a, yes, Commissioner?
In terms of topics for future agendas and meetings, Jack, do you keep a record of requests or recommendations that we make?
Yes.
Microphone, please. Sorry to put you to such trouble.
Do you keep a record of requests and recommendations that the commissioners make for future agenda items?
Yes.
Because, I think we've all made a number of recommendations at different times, and I'd like to see what those are, and I'd like to know when they're going to be agendized.
Okay, well, they're agendized at the discretion of the chair. But I can go back and look and see what's out there.
All right, is there a motion to adjourn?
You have to have public comment, I'm sorry, on this item.
Yes. All right, yeah, you remind me, public comments on the discussion that we just had. Or on this item.
New agenda. Ray Hart's Director of San Francisco Open Government, and I'm going to keep repeating it. I would like my case against Luis Herrera, which you heard intentionally while I was out of the state, brought back before this commission. I've already filed another complaint against him for the exact same reason. So I don't think the task force, having decided that he was in violation unanimously, well, not it was unanimously, Mr. Pilpel voted against it, will have any problem sending it back here. The bottom line is, Mr. Herrera, as I've talked to you about earlier this evening, hid $5,000 plus every year from the Friends of the San Francisco Public Library that he was receiving in gifts and items that he knew under the law he had to report. And we had to take him to the FPPC in Sacramento to get him found in violation, and he is a convicted perjurer. He filed those under penalty of perjury, saying he got nothing when he was getting $5,000 a year. And then when he came for the hearing, he stood here and he lied to your faces, and you don't seem to be worried about that at all. He told you this was not a First Amendment issue, which it always has been, from those 150-word summaries that I started on 6 years ago, to them telling people they weren't allowed to talk about certain things at Library Commission meetings, to our criticism of the financial relationship with the Friends, to his withholding documents, using his public position as city librarian to violate the law by withholding documents for more than 2 years. I had to go back to the city attorney's office, to the superintendent of records twice. Even the superintendent of records has been found in violation by the task force for failure to do their job, because it says that if they don't comply, it is supposed to be sent to the district attorney or the attorney general. And they pretend like that isn't happening. So basically what I'm saying is, this is not the first time you've had a case against the Library Commission or somebody with the library that was referred here. This is the 5th time. And every single time you have found a way not to have a hearing or to find that person not in violation. And I have to ask you honestly, do you want the public to believe that the Sunshine Ordinance Task Force is so inept that they could rule 5 times that the person is in violation, order them to follow it, have them not follow it, and then refer it to you, and every single damn time you find some way of kicking it out? The reason I think you do that is because what happened to Jewel Gomez, where you recommended unanimously to the mayor she be removed, and he ignored you. It's kind of hard to convince anybody you have any sort of authority when the person who you recommend somebody to just ignores your recommendation, doesn't even give you an answer.
And if you have refiled your complaint and it comes back to us, I assure you there'll be a hearing and you'll be present.
That's awfully polite of you.
That's awfully racist of you.
Yeah, it was intended that way.
Mr. Pilpel?
David Pilpel, again speaking as an individual. Just as clarification, yes, there have been joint meetings between the Commission and the task force in the past. There can be in the future. And I believe that one of the grand jury findings and recommendations, I believe number 20, talked about the relationship between the task force and the Commission. So you might address it in part in your responses to the grand jury report. If you intend to do something in the future, you could so indicate in your responses. The task force is certainly considering its responses to the grand jury report as well. Thank you.
Thank you. Now, I have a motion for adjournment.
I move that we adjourn.
Second. All in favor?
Aye.
Aye. Opposed? Stand adjourned.